Good morning, Mr. Williamson. You able to hear and understand us?
Sir, I can understand you.
All right. And Mr. McKinney, if you'll speak up so Mr. Williamson can participate meaningfully.
I am Jason McKinney. I represent James Williamson in 22 CF 2231. Mr. Williamson, can you hear me okay?
I can hear you.
Okay. Mr. Williamson is coming back from Florida State Hospital, Judge, and we would stipulate to the reports from Florida State Hospital at this time.
The court finds that the defendant is states so stipulate?
Yes, sir.
The court finds that the defendant is able to proceed at this time based upon the reports that have been tendered in the stipulation of the state.
And for the record, I did meet with Mr. Williamson in person at the Okaloosa County Jail yesterday. We had normal conversations about his case, and I believe that he fully understands what he is charged with and the potential ramifications. Mr. Williamson,
Yes, sir.
listen to me very carefully.
Okay.
The state at this time is going to offer an 11-month and 29-day sentence if you were to enter a plea as charged to the 4 counts that we discussed yesterday. That would be with an adjudication of guilt, so you would be convicted of a felony, but it would take into consideration the time that you have spent incarcerated and at the Florida State Hospital, so it would result in a time-served sentence and your release.
Yes, sir.
Okay? Is that what we discussed yesterday?
Yes, sir. That's what we discussed yesterday.
And do you have any questions for me or the court about what the offer from the state is?
No, sir. You said about plea no contest. They'll give me time, sir.
Yes, sir.
Yes, sir. That'll work, sir.
And is that what you wish to do today in court?
Yes, sir. Yes, sir. I do.
All right. Mr. Williamson, would you raise your right hand for me, please? Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, you heard what Mr. McKinney said just now regarding what the state's offer is to resolve this case.
Yes, sir.
And Mr. McKinney's also told me that he's spoken to you at length yesterday, I believe, about that.
Yes, sir.
All right, has he explained to you what the state's offer is?
Yes, sir. Time, sir.
And has he explained to you that it's required you to plead no contest to these charges?
Yes, sir.
And has he explained to you that you will be adjudicated guilty of these charges? Say again?
Yes, sir. I understand.
Okay. And has he answered all your questions about this plea and how it would affect you?
Yes, sir.
And are you satisfied with how Mr. McKinney has represented you in this case?
Yes, sir. I do.
All right. Now, do you understand by this plea that you're pleading no contest to these charges?
Sir.
And by pleading no contest, what I understand you to say is that you believe the state has the evidence necessary to convict you of these charges and you're not going to contest that.
You're saying no contest?
Yes, sir. That's what a no contest plea means to me, is that you believe the state's got the evidence and you're not going to contest that.
Not going to. Just plea no. Yes, sir.
Do you understand that by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir. I understand.
And so in this case, you'll be sentenced to 11 months, 29 days in the county jail, and the state stipulates that you have already served that time, and so upon entry of this plea, you would be eligible for immediate release from jail. Do you understand that?
Yes, sir. Thank you, sir.
Now, Madam Clerk, what will be the appropriate fines, fees, and costs in this case?
Including the public defender fee, it's $1,117.
$1,117, plus I show there's a $217.50 cost of transportation. Actually, there's 2 separate costs of transportation, aren't there? Is it the same amount?
It looks like a duplicate.
That's a duplicate. So So you'll have those fees and costs that you'll need to pay when you're released. Do you think you can get that done in 24 months?
Yes, sir.
Okay. Now, as long as you're making payments, if you need more time, then all you need to do is ask, and I'll give you more than the 24 months to pay as long as you're making payments, okay?
Yes, sir. Thank you, sir.
Okay. The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication in this case. Thank you, Mr.
Thank you.
Williamson. And we'll need fingerprints at the jail, please.
Yes, sir.
Thank you.
Thank you, Your Honor.
Thank you. All right, and I see Mr. Cobb is not connected, so I'm not sure what.
I messaged him. He's in the middle of a TPR trial, I guess, as well. He came back on. Then Judge, I think Warren wanted him to come back, so he said he was going to try to check back in whenever he's
Okay.
on break.
All right, just let us know. Ms. Jaquette, good morning.
Good morning, Judge. The first I have is Jarius Hill in 24 CF 2280. Katie Drakewood on behalf of Mr. Hill, Your Honor. We are here for a bond hearing. Your Honor, I don't have any witnesses, and I did file a fairly detailed motion kind of outlining the posture of the case and what would be my intended arguments, mainly that Mr. Hill is, if released, is still subject to the conditions of his community control that he was sentenced to. Basically, he was pending another case, he resolved that case. A couple days later, after bonding out, he was rearrested on a second case that actually happened before the first case, but for whatever reason, the 7 or 8 months he spent in jail on that other case, they didn't see fit to serve that warrant on him. So he is essentially starting all over with a new case, but he's still subject to the terms and conditions of the community control that he was placed on in the other case. Since I wrote the motion, I will tell the court that I have discovered that the alleged victim in this case now lives out of state, up in the Northeast, I believe somewhere in New York State, so there's no concerns about Mr. Hill having any contact with the alleged victim, even incidental contact. So we would just ask that the court reduce the bonds, as we outlined in our motion, to $5,000 on count 1 and $2,500 on count 2.
All right, State.
Your Honor, this is a situation where Mr. Hill committed 2 crimes that were almost identical the way they were carried out. They were both had store clerks held at knife point to open up a cash drawer. The case that Mr. Hill pled out on, there was an identification almost immediately that he was ID'd as the defendant who committed the crime. In the first case, it was unclear, and there was a long period of investigation. And so when he pled to the case that he pled out to, at that time it was unknown that he was the defendant in the robbery before. And once it became known, you know, then that sentence didn't look very appropriate. But needless to say, he'd already entered the plea. So it wasn't a situation where the state just sat on a warrant that we didn't have served. He just wasn't identified until later on. And Ms. Jaquette is correct in that lost my train of thought here. Anyway, the state's position is that the fact that there was a knife used and there was 2 robberies that were, okay, yes, that it was like 4 days apart. like the exact same fact pattern. The violent nature of it, $105,000 cash or professional bond is low in the state's position. So we'd ask the court to respectfully deny the motion.
And I'll just state, Judge, and I don't have these dates before me, so I won't give the court specific dates, but just my reading of the warrant. And I don't believe this was an issue with the state. I believe it was more an issue on the part of law enforcement, just dragging their feet to get the warrant to the state. But the date as to when the alleged fingerprints matching Mr. Hill's came back and the date as to which the warrant was actually signed and finalized was a pretty significant distance in time. I think they probably could have gotten him served prior to that. Law enforcement is an arm of the state, so it is imputed to the state that the delay ultimately falls to them because law enforcement is an arm of the state. However, I don't believe it was at the state attorney's office that the delay occurred.
The state's position is that the facts that matter here are that Mr. Hill committed 2 armed robberies at knife point store clerks in our county. And that's very dangerous, and based on that,
No, and I understand it. What I understand Ms. Duquette to say is this. If that's the case, then why was he offered a probationary sentence and released into the community? And reading the addendum of probable cause on the case in which he's currently held in this bond, it alleges the operative events are April 11th. In the case which he is on probation, the operative events were April 15th. The addendum of probable cause in the present case says the latent prints from that were obtained were submitted to FDLE, and the FDLE identified the latent prints as belonging to the defendant. And then that was submitted, looks like on 9/27 for his arrest. So I guess for the court to understand your argument, when was it that the state knew that the defendant was the person that was alleged to have committed the crime in the present case? What is it, the 2208 case? When did those prints come back, identifying the defendant as the person alleged to have committed the crime in the 2208 case?
so it's an interesting situation in that with his last name is not on my alphabet. It's a different division. But in the first case, there was a lookout working with Mr. Hill that got charged right away. He was identified, and it got assigned to me. The ASA in the Division 1 had no idea that this case, it was after a plea had already been entered. When I got assigned this case, that's when I realized, hey, this guy's on probation. And then I saw that he had already pled out to one, and I looked at that. When the ASA didn't have any idea that he was even a suspect in another robbery. So that's how that worked. So
Right. In the 872 case, the case he's on probation for, and I guess that was a bad question that I asked. The 872 case, he was arrested, looks like on 4/16 of 24. And this case proceeded, and then there was a voluntary resolution of the case on 8/19 of 24. Then in the 2208 case, the warrant was submitted, looks like, on 9/27. Stand by, that might be wrong, stand by. Yeah, it was submitted to Judge Clark on 9/27 and signed on 9/27. So my question is, when was the defendant identified as the person alleged to have committed the crime in the 2280 case?
And I cannot give the court that information. I have received a substantial amount of discovery in this case, but I have not received that FDLE fingerprint examination report, so I don't know what the date of that report is.
Because, see, that's material to the court's inquiry, because if they didn't find out because they didn't have his prints until after this other case, I understand what Mr. Snell's saying. If the identification of the defendant was there and the delay was on the state, then I understand what you're saying, but that's the question the court needs to have the answer to. When was he identified?
And I'll have to defer to Mr. Snell because, like I said, I don't have that report, Judge, so I'm not, and that information isn't in the reports stating, like, we got the examination report back at a certain date or whatever.
Right, and when the warrant was supplied to, submitted, that's when our office found out about it. So, but that's, and that was after he had already pled.
Because he pled in this case, in the 872 case on 819. So you don't know, is what you're saying.
That's correct. I know that our office, when we realized that was once the warrant became active for his arrest in this case.
Right. Well, you want to put on evidence, Ms. Jaquette, regarding your request for bond?
Your Honor, I can have Mr. Hill testify to the information in the motion, but that's essentially what we've got, Your Honor. Like I said, I can't tell the court or present any evidence to the court of when the state got the fingerprints because I don't have that report to present to the court. So I'm kind of hamstrung in that situation, Your Honor. So I can certainly have Mr. Hill testify to the information that has been put in the report, but I think that's all pretty much, yeah, I would basically just ask the court to take judicial notice of that information because all of that information is in the court file in the 872 case number. I think the strongest argument I have for the court is that Mr. Hill is on community control. So the minute he gets out of jail, he is confined to his home. Not only will he have a bondsman keeping track of his whereabouts, but he'll also have a community control officer tracking his whereabouts. He'll be meeting with a community control officer weekly. He's willing to submit to pretrial release as well if the court wishes. But, you know, the stricter conditions are going to be his requirements on probation while he's on community control especially. So that is to say, Your Honor, I don't believe that I have any evidence that's stronger than the information that's already in the court file that I just asked the court to take judicial notice of for the purposes of this motion.
Well, based upon the record the court has before it and the information the court has, and I'm looking at the warrant application, which in the 2280 case, which recites the operative date of 11/20/24, and does not say when the prints were returned from FDLE identifying the defendant. However, The application for the warrant was done on 9/27, approximately a month after the defendant's plea in this case, and submitted to the court, at which time the court entered the warrant directing that he be held for first appearance, and at first appearance he was then held for pretrial detention pursuant to the operative statute, and the court at that hearing found that the appropriate amount of bond was the one that the court set. And considering the probable cause, both of the case in which the 872 case, and because the statute says I'm supposed to consider prior behavior in determining the appropriateness of bond, and the alleged present behavior, this represents a criminal episode, and the allegations in this case are that the defendant went behind the counter, brandished a knife, and demanded that the clerk open the register, and then and therefore he was charged with armed robbery with a weapon. And if the addendum probable cause in 872 is consulted, then less than 5 days later, actually 4 days later, he did the same thing in another place using another dangerous weapon to commit an armed robbery. So the court, under the circumstances, finds that the bonds in this case are appropriate based upon what the legislature has told the court it should consider in determining the appropriateness of bonds for dangerous crimes. So the motion is denied.
Your Honor, may I approach with a written order on that?
Granted.
And I did fill out the written order.
Okay, thank you, Mr. Chair.
Your Honor, the next I have before the court is Arsenio Lovelace. He is here to enter, come on, Arsenio. He's here to enter a no contest plea. If I may just pause for a moment. He has reviewed the plea agreement, but I just need to have just for probation's information, Mr. Lovelace does have a hold out of Walton County. He has a hold out of Walton County, so he will not be released to the community. Your Honor, before you is Mr. Lovelace in case number 25 CF40. He's going to be entering a no contest plea as charged. Essentially, he'll be placed on 3 years of probation. It will run concurrently among the two charges. He will have the opportunity of automatic early termination at 18 months. If everything has been completed, there have been no violations, and he's paid the entirety of the restitution. He will need to pay the $40 per month cost of supervision based on the amount of restitution. I will be asking the court to waive that, especially since Mr. Lovelace is in jail and now has a hold out of Walton County. It will take him some time to get employment. He does need to pay the $515 in court costs, the $150 cost of defense, complete 24 hours of community service work. He's not to trespass at the Fast Cash Advance in Fort Walton Beach. And he'll need to pay $7,000 in restitution to the Fast Cash Advance. That address is 60 Beale Parkway, Fort Walton Beach. And again, automatic termination at 18 months. May I approach?
Granted.
And there's no objection to the score sheet, Your Honor. And I believe Mr. Gomez did mark the amount of probation on that.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Katz said just now?
Yes, sir.
You signed the written plea form.
Yes, sir.
How old are you and how far did you make it in school?
37, some college.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And that's what you read in the plea form, what Mr. Kett just announced?
Correct.
You understand by this plea arrangement that you're pleading no contest to the charges?
Correct.
And that says to me, you believe the state has the evidence necessary to prove your guilt and you're not going to contest that?
Correct.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Correct.
In this case, you'll be adjudicated guilty. You'll be sentenced to 3 years of probation with some fees, costs, and the standard conditions of probation, plus you can't go back to the fast cash. And you've got the restitution, which was announced to fast cash, and you'll have the ability to automatically terminate if you have no violation and you've paid all of your restitution.
Yes, sir.
Has Mr. Kett answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how she's represented you in this
Totally.
case? And so long as payments are being made towards the restitution, the court will waive the cost of supervision. The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. You step over this way for your fingerprints, please.
Your Honor, the next is Douglas Neal before the court. Your Honor, Mr. Neal's before the court in 24 CF 2548 for a bond hearing. Your Honor, I did have a few further, obviously the court knows I tend to write more detailed motions in this. I had not, when I filed this motion, had an opportunity to review the discovery yet. I have since done that, so I do have a few other bits of information I wanted to provide to the court. First of all, Mr. Neal's score with this charge is 44.8 points. The only prior that he has that could be considered a, quote, violent charge would be a felony battery charge from 2018, so about 6.5 years ago. Mr. Neal is a 67-year-old, 160-pound man. The alleged victim in this case is a 19-year-old, 180-pound man. We have not been able to get depositions scheduled until April 28th. That was the first available date the state was able to provide me with. Also, based on my reading of the CAD report in this case, it does not appear that the alleged victim in the case speaks English, or at least not well. And so I have some concerns about the information that was relayed in the incident report because I don't believe there were any Spanish-speaking officers on scene. Also, there's an indication that a written statement was collected, but that wasn't provided in discovery. So I don't know if the state's even been provided that information yet. But basically, I just want to make sure the court was aware of that information. I think that there's definitely more to this case than the short one-paragraph police report that I got and the information that I got. It just doesn't seem as plausible as and simple as that. Your Honor, but Mr. Neal has never failed to appear for a court date. He does have a home in Fort Walton Beach. He's lived here for the last 35 years. The purpose of bond is to ensure safety of the community and to make sure that that Mr. Neal appears in court with no prior record of failing to appear. I don't think there's a concern that Mr. Neal will appear for court. I've represented Mr. Neal in the past, and he's never been an issue for me as far as staying in communication with me. And that, based on the safety of the community, I definitely, like I said, I think there's a lot more to this case than what is reported just in the police report. Unfortunately, I won't have the opportunity to explore that until April, the end of April. So, and that is not 100% on the state. I think they had an earlier April date, but I was not available to be there because I have misdemeanor court obligations that day. So I don't want to, I'm not trying to mislead the court or blame the state for the late date. It's just that that was the first available date that we could both be available. That means that he's also going to need another continuance, and the first available court date is going to be the May 12th docket. And he's already been continued once. So we are asking that the court reduce his bond to a signature bond. Mr. Neal is, as I previously stated, 67 years old. He does not have the funds to make a monetary bond.
State?
Yes, Your Honor, at this time, the state would request that the motion to reduce the bond be denied. In this case, when we're looking at the factors or criteria that the legislature has laid out for the court under 903046, we look at the nature and circumstance of the offense charged. In this case, I can't really speak to whether or not or have the efficiency of communication on scene. All I can go off of is from the report that I have. In that report, the individual or the defendant approached the victim, appeared to have been asking for some money, attempted to grab the bike, actually swung a stick at the victim allegedly, and then ultimately ends up using what law enforcement described as a rusty cobalt razor, closed razor knife that he ended up hitting the victim with. The victim stated that once he realized that it was a weapon, he ran away. I understand, or I can't understand the significance of the height and weight of both the victim and the defendant. However, the state would argue that once a knife comes into play, that definitely changes the scale somewhat in terms of whether or not an
Yeah,
individual.
but the charge is without weapon, right?
That's correct, Your Honor.
That's correct. As, I'm just going off of what the report states, Your Honor. We did collect a knife. We're requesting the fingerprints are ran on that. I think based on that report that we get back from FDLE, that would perhaps dictate an amended information. But I'm going off of what the report states, not necessarily what we charged, Your Honor. In looking at the criminal history of the defendant, Mr. Quet's correct. There is, in terms of violence, there's merely only a felony battery and a battery. There is also a grand theft, sale, manufacture, deliver, and some drug charges, Your Honor. We feel as though the bond in this case, which is $10,000 cash professional, is reasonable given the charges, and therefore we respectfully request that this bond remain in place, Your Honor.
And I would like to just point out that what I will consider the more serious charges, the sale, manufacture, deliver, the felony charges, the grand majority of those are over 25 years old. So had Mr. Neal not gotten some misdemeanors and some possession charges along the way, I think one possession charge, we may not even be talking about that being on his score sheet. They were late 90s charges and very early 2000s.
Where will the defendant be living if he's released?
Your Honor, Mr. Neal actually has a residence that he has regularly lived at. If I may just grab my motion really quickly. That address is 659 Anderson Street in Fort Walton Beach. And Mr. Neal has been living at that address for some time now. This is not a new address. It's not a friend's address. This is the address that Mr. Neal resides at.
Okay, who else lives there?
I believe Mr. Neal lives by himself, correct? He does occasionally, I believe one of the witnesses in this case was staying with him briefly, but she does not actually live there. So he does occasionally allow other people to stay if necessary, but this is his address. He lives alone. But there's no concern about him needing to rely on someone else to allow him to live there. This is his residence. And I would just like to comment on if the state intends to wait for fingerprints, if we're gonna go off of Mr. Hill's case, we've got 6 or 7 months we're now going to have to wait for them to get those fingerprints back. So that just delays Mr. Neal's case even longer.
And the motion says that he is employed doing,
Construction, Your Honor. I don't, I think Mr. Neal is, works intermittently, Your Honor,
okay,
when he can find work that he's able to perform.
looking at the totality of the facts alleged in the indictment of probable cause, the court finds it reasonable under the circumstances to grant a bond reduction. However, that is going to be with pretrial services, weekly reporting by phone, monthly reporting in person, house arrest sanctions, with him to be at his address at all times unless he's involved in gainful employment or attending court or otherwise organized by pretrial. And with that, I'll reduce it to a signature bond.
And Your Honor, in order to make sure that I get this drafted correctly, would the court allow me to submit
Yes.
a
Yes, and he
not
should-
in court drafted order?
Right,
And would,
he's not to be released on the minutes, only upon the written order.
yes, and I will get that to the court before lunchtime, so they'll get it taken care of, okay?
No contact with the victim.
Do you understand house arrest? That means when you get released, you go to home and you don't leave home. Got it? Okay, and then call me. Okay? All right, see you later. Yeah. Your Honor, the next I have before Your Honor is Naraya Rudolph. Your Honor, Mr. Rudolph's case numbers on the docket today are 19 CF 2646 and 19 CF 1473. I believe the 1473 case number still has the Public Defender's Office appointed. There was a discrepancy in the case number that was sent on the order. One was correct, the other had a 2016 date instead of a 2019 date. An amended order has been provided to the court, but obviously I'm aware that they intended for me to get both cases, so
You're appointed in the 19 CF 1473 case.
Thank you, Your Honor. Your Honor, in this case, we're going to enter a denial. These are both VOPs. Mr. Rudolph has a new case that is on the May pretrial docket. That's 25 CF 293. We just ask that these cases run with that new law violation so that I can get up to speed on everything.
The denials entered, these two cases will run with the new case, Madam Clerk.
I just got your cases. Your Honor, the next I have is Tykeia Washington. Your Honor, this is Tykeia Washington before the court, 23 CF 699 and 23 CF 1691. For fear of sounding like a broken record, Mr. Washington has two BOPs on the docket. He has a new law violation, 25 CF 128, also on the May pretrial docket. I'd ask to enter a denial and have these cases run with the new case so I can get up to speed on the new case.
Denials entered, and we'll ask the Madam Clerk to move these cases to run with the new case.
Thank you, Your Honor.
All right, thank you very much.
And Your Honor, I have one other matter that's actually on the 1230 docket, but the state indicated they'd be moving to it for a continuance. That's Ozzie McClendon, 25 CF 330. They did bring him up so that we could address this, so he's not sitting. Your Honor, Mr. McClendon's case, my office already represents the alleged victim in a dependency matter. We have been in that posture for almost 2 years now, so we will be withdrawing from Mr. McClendon's case. I got the order this morning. I had my office start opening it before I left so that we could get that filed today.
All right, I see the public defender's motion and then your appointment, and so it'd be Mr. Nopes, correct? Mr. Nopes.
And so I will provide that order with I will call my office as soon as I leave here and have them put in Mr. Nopes so we can expedite
Correct.
getting that order signed. This was set for a pretrial detention hearing today, Your Honor. quite frankly, based on information I have about the alleged victim in this case from our representation, I am going to be precluded from making any arguments on behalf of Mr. McClendon, even if the state was prepared, but it's my understanding that a crucial witness in the case is not available due to illness. And so the state was going to be moving to continue it. So I think it would be prudent to continue this to next week's pretrial detention docket, to allow the state to have their witnesses and also to allow Mr. Nopes to get up to speed.
All right.
Do you understand what you're saying? Okay. Thank you, Your
All right, So
Honor.
we'll reset this for next Thursday, which I guess is the 27th.
And that will be at 12:30, I'm assuming?
Correct.
Okay. And I will let Mr. Nopes know. I've also just for the record, I told Mr. McClendon, I explained what the conflict was. I explained why I wasn't able to keep him as a client, and that Mr. Nopes being appointed means that they'll be able to meet and get up to speed before next week. So,
All right.
Marty Nopes? Give me 1 second. Can I give him a piece of paper with the name on it? Is that okay? Can I give him a piece of paper with Marty's name on it? Okay. If I can get my fingers to work. I don't have his contact information, but I'm gonna ask him to come out. If someone from the family called, I'll give his contact information to them. I just don't know off the top of my head, okay? Okay. And with that, Your Honor, that's all I have for the court.
Anticipate any further withdrawals today?
No,
Y'all?
No, Judge.
Okay. All right, thank you, Ms.
May I be
Jaquette.
excused?
Yes, ma'am.
Thank you.
Judge, real quickly, just before we move on, it's not with you. It was in a previous case, probation brought to my attention. I just wanted to correct something on the record if possible. It's Alliance Culpepper. In that, we extended probation for a year. Probation let me know we need to, on the record, just state that probation was extended from a year from today.
Probation is extended a year from today.
Thank you, Judge.
All right. Mr. Trell.
Good morning, Your Honor. Richard Trell, appearing on behalf of Nathan Wood, case number 2016 CF 894. Mr. Wood is incarcerated. This is on a violation of probation, Your Honor. And while we're waiting on Mr. Wood to appear, what are the continuance dates, Your Honor?
For a VOP, it's going to be 417, right, Madam Clerk? 417.
All right. And if we could, is it possible to do the only issue is originally this appeared to be assigned to Mr. Snell, so I had spent some time getting in touch with Mr. Snell to discover it was Ms. Barrickman. And so I haven't had a chance to go over what my discussions with Ms. Barrickman have been with my client. And so my concern would be, I don't think this is going to go to a trial.
We'll set it then at 9 o'clock, and if you have a resolution, then anytime I'm here, you can contact Madam Clerk and Mrs. Natali and get it set, and we'll take a plea.
Yes, Your Honor. Well, at that, if I might just briefly discuss what I've got from Ms. Barrickman. Of questions, could we bring this back on the 1:30 docket?
I don't know what our transportation thing is, because we have a large number of folks coming for arraignments at 1:30, so if we can accommodate that, I'll do, but I'd have to ask detention if they have the ability to do that, Mr. Trell. I mean, I'll accommodate if I can, but we've got quite a few people, and it would be up to them whether it can make it
All right.
happen.
Well, Your Honor, if I could arrange to meet with him in the council.
Can you put him in the witness room, in the interview room?
The interview room is open, and they just told me he can stay here if his attorney wants to do. Until 1:30. They can accommodate that if you want to, unless you keep the room open if you want to.
Your Honor, if we could just bring it
If
back in
you
a few
let
minutes.
Mr. Trell meet with him in the interview room, that'd be great, and we'll pass
Thank you,
the
Your Honor.
case.
You're gonna go with them, and I'll come around to the end.
All right, so PD, which of y'all wants to start first?
Judge, I have an out-of-town.
Okay.
May I call Mickey Smith?
Smith, please.
Ms. Smith is present and approaching in 21 CF 3255. We've reached an agreement in this matter. Ms. Smith is going to be withdrawing her previously entered plea of not guilty and earn a plea of no contest as charged. The agreement calls for a withhold of adjudication. Keep your hands out of your pocket. Sorry. 3 years of probation concurrent with 21 CF 2090. Reserve over the issue of restitution for 180 days. $515 in court costs, $150 cost of defense. May I approach with the plea agreement and the score sheet?
Yes. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. You can put your hand down. You heard what Mr. McKinney said on your behalf and signed the written plea form?
Yes, sir.
All right. And how old are you and how far did you go in school?
42 and graduated,
All right.
12th grade.
You able to read and understand the plea form?
Yes, sir.
And did you do so before you signed it?
Yes, sir.
And is what you read what you just heard Mr. McKinney say?
Yes, sir.
All right. Do you understand by this plea arrangement that you're pleading no contest to the charges?
Yes, sir.
And that tells me that you think the state's got the evidence they need to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
And in this case, adjudication will be withheld. You're going to be on 3 years of probation, and that's concurrent with your other case. And restitution may be established later at either by agreement or at a hearing, and that'll have to be done within 6 months.
Yes, sir.
With fees and costs correct, Madam Clerk?
Yes, sir.
And you'll have those fees and costs plus the standard conditions of probation, which you've already been instructed on in your other case.
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, you've already reported probation once, but you're still going to have to do it again. Before you leave, check in with them and they'll give you instructions, okay?
Thank
All right,
you.
thank you now. Good day.
Thank you, Judge.
All right. Mr. Klein, do you have anybody in the gallery?
I have a couple in the gallery, Your Honor. If I could call Mary Mason.
Mary Mason, please.
Your Honor, this is Miss Mason. She did attend drug court yesterday. She is in that process. If we could put her case on the first available date in April for status, I expect that she's going to enroll in the program before then, and this will come off the docket.
State have objection for drug court status next cycle.
No objection, Your Honor. Just for the court's awareness, Ms. Henderson has been in contact with me. It looks like she's tracking for entry into the program, hopefully either next Wednesday or the Wednesday after that, Your Honor.
Okay. All right, so follow their instructions and attend, and we'll leave you on for status. Mr. Klein's or your lawyer in drug court will let you know if you need to be back here in May. That's merely a status to be certain the case doesn't get lost, okay? Okay? All right. Thank you very much.
Madam Clerk, is that the 17th?
Yes.
Okay, thanks.
Is it April 17th?
Yes.
All right, keep doing what you're doing. Okay, all right. The only other one I have out of custody right now, Your Honor, is Ricky Minor.
Ricky Minor.
Mr. Minor is present and approaching. I did talk with Mr. Gomez. The state is going to agree that if Mr. Minor pays the restitution in 24 CF 1236 up front, the state will dismiss the violation and terminate supervision. Mr. Minor just had a setback with his vehicle. He's going to work and try to get this paid by April 17th. If we could continue this case without subpoenas to April 17th, hopefully we can get it off the docket before then anyway.
State?
No objection, Your Honor. The restitution being paid is our biggest priority right now.
All right, and how much is due on restitution?
I believe it's a little over 800 or right at 800. Your Honor.
Correct, Your Honor. And I believe that's to the school district.
Yes, it is.
Okay. All right, so we'll leave it on both cases without subpoenas for status.
Yes, sir.
Okay. All right, see you then. Stay in touch with Mr. Kleins, Mr. Minor.
Mr. Minor, if you can, just let Mr. Kleins know the second you pay that so that we can handle it and get it off the docket before that. Go.
Mr. Koch.
Yes, good morning, Judge.
Good morning.
Judge, first, if I may call Mr. Teron Sweat, who's present and approaching. This is 2023 CF 2479. Yes, Your Honor. This was scheduled for a motion to suppress. We will be withdrawing that motion, and we'll be entering a no contest plea this morning, Your Honor.
All right.
And Your Honor, it's going to be count 1 will be a lesser included offense, possession of a controlled substance. That's Florida Statute 893.13, subsection 6, subsection A alpha. That will be a withhold of adjudication, $615 in court costs, $150 in defense costs. Count 2 will be a lesser included offense of carrying a concealed weapon, Florida Statute 790.01, subsection 2. That will be adjudication of guilt, credit for time served. Counts 3 and counts 4 will be no pros, Your Honor. If I may approach with the signed plea form.
Granted.
Mr. Snell will follow this up with a score sheet.
All right. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
And you may put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
All right. And how old are you, and how far did you go in school?
38 high school.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Koch just announced to the court?
Yes, sir.
All right. Now, first I want to address your lawyer on your behalf filed a motion to suppress, challenging the lawfulness of certain of the actions of law enforcement. And I believe based upon how that motion was drafted, that would be a dispositive motion to suppress, would it not, Mr. Koch?
That's correct, Judge.
All right. Which means that if the court were to grant that motion, the case would be dismissed. By entering this plea, you understand you're giving up the right to make that challenge.
Yes, sir.
And do you believe that making this plea represents a decision that's best for you under all of the circumstances presented?
Yes, sir.
Okay. Now, you understand you're pleading no contest to count the lesser included offenses in count 1 and 2, and count 3 and 4 will be no prost.
Yes, sir.
And with that, and based upon your withdrawing the motion to suppress, are you making this no contest plea because you believe the state has the evidence necessary to convict you, or because you believe it's in your best interest to make this plea?
I believe it's in my best interest.
Okay. And that's based upon your discussions with your lawyer and his advice to you regarding the potential outcomes of this case?
Yes, sir.
Okay. And after all of that, you think this is the better way?
Yes, sir.
Okay. Do you understand by making this plea, you are giving up your right to the motion to suppress and also the right to a trial where the state would have to prove you guilt beyond a reasonable doubt?
Yes, sir.
Now, you're going to be so on count 2 is an adjudication of guilt,
Correct, Judge.
credit for time served, and I'm just annotating the plea to make clear that it's a withhold on 1 and an adjudication on 2. And are the fees and costs correct, Madam Clerk?
Yes, sir.
And you'll have those fees and costs that you'll need to pay. How much time do you reasonably think you need to pay the fees and costs?
Could I get a year?
Yes, sir. And as long as you're making payments, if you need more time, I'll give you more time, okay?
Yes, sir.
But you need to be making the payments for me to extend the period of time. The goal is to get them paid, not just to extend the time. Does that make sense?
Yes, sir.
Okay. Now, Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with what he's done for you at this time?
Yes, sir.
All right. Probation?
Just to clarify, is count 1 probation or is it credit for time served?
What, is it probation?
No, it ultimately be credit for time served, Your
It's
Honor.
no, it's a straight plea. Okay. All right. Court will find the plea to be freely and voluntarily entered into, and we accept the plea with the adjudication on count 2. If you'll step this way, please.
Yeah, just for further clarity. Yes, sir.
And you'll follow that up with a score sheet, please.
Yes, sir.
Okay.
Judge, if I may call Mr. Robert St. Pierre, who is present and approaching, and this is 24 CF 2485, Your Honor. And Judge, this will be a no contest plea this morning.
Can you repeat the name, please?
I'm sorry, Robert, last name is St. Pierre, and that's 24 CF 2485.
Thank you.
Yes, ma'am. This will be a plea of no contest, Your Honor. Count 1 will be no pros. The remaining count 2 misdemeanor will be adjudication of guilt, credit for time served, court costs, and there's 150 in defense costs, Your Honor. If I may approach with the signed plea form and no score sheet for that.
All right, it's misdemeanors only, right?
Correct, Judge.
Okay.
Count 2.
Do you get that, Madam Clerk? Count 1 is no pros, count 2 misdemeanor only,
Yes, sir.
and this is credit for time served. Proper court costs, Madam Clerk?
270 and then 150 for the PD.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right. And you put your hand down. You heard what Mr. Koch said. You signed a written plea form.
Yes.
You understand you're pleading no contest to the count 2. Count 1 will be no pros. You'll have the fees and costs that were announced, and you'll be adjudicated guilty.
Yes, sir.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes.
Are you satisfied with what he's done for you?
Yes.
All right. You've got the fees and costs that were announced. How much time do you think you'll need to get those paid?
If you could give me 12 months, that would be ideal.
Yes, sir. I'll give you a year, and if you need more time, as long as you're making payments, I'll give you more time to get it done, okay?
All right, thank you.
All right, thank you now.
Thank you.
You're welcome. Judge, next, if I can call Mr. Savion Reed, and that's 21 CF 193, and he's present and approaching. Yes, Your Honor. Your Honor, this will be an admission this morning. It'd be to maintain the withhold. Probation will be modified and to extend the probation for a term of 24 months, Your Honor. There is the $100 cost of prosecution, the $150 in defense costs, all original costs and conditions. There is a stipulation, a minimum payment of $150 per month towards the restitution. There will be an automatic termination of probation once the restitution is paid off, in this case, Your Honor. And I am asking if we can waive the cost of supervision moving forward, because that remaining sticking point of restitution is what's holding this probation up, Your Honor. If I may approach with the signed plea form.
Mr. Carter,
Yes.
his past term needs to be extended from today.
Extended from today? Okay, thank you. So, Your Honor, just probation's comment, probation was terminated or ended, so it would be 24 months from starting today.
Okay, so probation is extended 24 months from today.
If I may approach, Judge.
Granted. Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said. You signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that says to me that I violated just the way the affidavit report says I did.
Yes,
All right. And you understand you're waiving your right to a hearing where the state would have to prove your violation.
yes, sir.
And in this case, your adjudication will continue to be withheld and will extend the probation 24 months from today with the fees and costs were announced and the minimum of the amount towards the restitution. And as soon as the restitution is paid off, then you can automatically terminate, assuming you have no other violations.
Yes, sir.
All right? And so long as you're making that $150 payment towards the restitution, I'll waive the cost of supervision.
Yes, sir.
Court will find the plea to be freely and voluntarily enter into and accept the plea. Thank you.
Thank you.
You're welcome. Your Honor, that's the last I had out of custody.
All right. Who else? Everybody else in the gallery here for someone in custody, or have you got a case? Anybody have a case today? All right. Do y'all not have lawyers? Is that what it is? Crooks.
Oh, we can handle it, Your Honor. I spoke.
Come
with
on down,
Mr.
Mr.
Griffith.
Crooks.
I think this is going to be in benefit to Mr. Crooks. Just for the court's awareness, Your Honor, Mr. Crooks has consistently been in this courtroom trying.
Yes, he has.
Trying to get this.
Doing everything he's
probation
supposed to do.
terminated. There was a couple ends that I wanted to make sure were squared away on our end. I spoke with Mr. Griffith yesterday. He informed me that his entire office has been hit with the flu. He himself has it, so I think that may be why he might not be here. I just wanted to let the court know that I have spoken with him. The state has no objection to terminating his probation. It has been a very, very long time for Mr. Crooks. He has jumped through a lot of hoops. He's started a business. He's doing a lot of really good things, and so we have no objection to really terminating probation.
All right. Probation is terminated. Thank you, Mr. Crooks.
Thanks, sir.
Samuel Homestead will be next.
All right. Mr. Olmsted, you're here today without a lawyer. Do you want a lawyer to help you? Or would you like to hear what the state has to say first?
I'd like to hear what the state has to say.
All right. Olmsted, Samuel Olmsted.
Yes, Your Honor, let me flip through quick. Your Honor, at this time, the state would be offering adjudication of guilt, admit the violation of probation, 39 months, then Department of Corrections, revoke and terminate probation, Your Honor.
Okay.
And that would, the 39 months is the guideline sentence.
All right. Mr. Olmsted, do you understand what they're saying?
Not at all.
Okay. Well, they're saying that they want, their offer to resolve the case is for you to go to prison for 39 months. Would you like a lawyer to help you?
Yeah,
Can you afford one on your own?
No.
All right. I'm going to give you an application now to complete. Turn that in. Don't leave until you turn it in and get a new court date, okay?
Okay, cool.
All right?
James Jenkins will be next.
Jenkins, please.
Yes, sir.
All right. Good morning. You're here today without a lawyer. Do you want a lawyer to help you? You would like to hear what the state has to say first?
state has to say, Your Honor.
All right. James Jenkins, state.
The only thing you got left is the victim impact panel.
It's done.
Done VIP as well?
He completed the victim impact panel last night,
Sweet.
and he has shown proof that he has completed DUI school.
Okay, so then let's terminate his probation and send anything voluntary to collections if we can do that. Good job, sir.
Thank you.
All right, so if you've got some financials left, do you have, he has financials left?
Yes, sir.
All right, so we'll terminate your probation. How much time you think you need to get your financials paid?
As long as you can give me a year, I guess.
I'll give you a year to get all your financials paid, as long as you're making payments. If you need more time, all you need to do is ask.
Okay.
And I'll give you extended time. But don't ask if you're not making the payments, okay?
Yes, sir.
All right, thank you very much. Check in with him one last time before you leave.
Is the VOP dismissed or just terminated?
Is VOP dismissed and then he's allowed to terminate? VOP is dismissed and terminated.
Jamie Cron.
Jamie Cron. Good morning. You're here today without a lawyer. Do you want a lawyer, or we want to hear what the state has to say first?
I was just here to, I
Okay.
guess, tell you I got everything done.
Okay. You got everything done?
Wait, hold on real quick. Let me try to, probation, is that accurate?
Just 1 second. All the officer said was recommend credit for time served or revoking term. So just 1 second.
Because I'm showing that he still owes court costs.
Don't see that his money's paid.
So 810, 12 cents.
I don't see that his monies have been paid off, Your Honor.
I paid it off on the 2nd,
To where?
to the courthouse.
You paid it directly to the clerk?
Yes.
Did you inform your officer of that?
Yes, I told her that on the 3rd when I saw her. She
Okay.
turned the paper in a week before I was supposed to see her.
Madam Clerk, has he been paid?
I do not see it paid in that case, but let me see if there's another case maybe the payment was applied to.
Because we show a balance of $4,886
That's a
and
different
88
case.
cents. Huh?
That's a different case.
Because in 2185, I show $810.12 in outstanding costs. And other than that, has he completed the other conditions which were incomplete in the report?
I
So
finished,
just the case number 212185 on the monies, that is paid, the other case is not paid.
The other case.
There he says he has another case, 23615. That's where the monies are showing.
23,615.
I'm still trying to fight that one.
Hold on just a second. Let's.
That one, for some reason, is not in violation status. 23,615 isn't.
23 CF 615?
According to CCIS, is not in violation status.
Well, that's not him.
4 years.
That's not him.
Oh, he's talking about, there's a Walton case. The 23 CF that I'm looking at for him, that's 615, that's a Walton County case.
So as,
The only thing that he has open with us in Okaloosa County is 21 CF 2185, unless he transferred his supervision over from Walton, but as
Yeah,
we're
it was
here,
transferred here.
as we're here today, that's not our concern. Our concern is on
Right.
21 CF. And if they're saying all of his money has been paid,
Not, okay, according to it's hard to separate in our computer, but on the clerk of court for this 21 case, it's still showing the balance.
right, the
I
clerk
paid-
shows a balance of $810.12.
I paid $1,200 on the 2nd.
To Okaloosa County Clerk?
Yes, sir.
Do you have a receipt?
She never gave me one.
They always
When I
give you
saw
a
her on the
receipt.
3rd, it was online when I paid it. They charged me $24 and some cents for paying over line.
And I also see that he hasn't completed the 24 hours of community service.
I have it on my piece of paper, on my phone, that they sent me a copy that I completed it 2 days
Did you show it to
ago.
your officer?
I haven't seen her since the 3rd.
Okay, well, she wouldn't have the paperwork for you to give to
She
her.
told me to, no, I have a copy that, Ampet gave me.
I think, Your Honor, for the sake of efficiency, if we want to set this for 4/17 without subpoenas, that'll give him time to make sure that he coordinates with his officer, because
She told me
it
to-
sounds like if he did all of these things, I'm tracking towards dismissing this and terminating supervision. But I want to make sure that his officer has everything she needs for their file before we do that.
Because see, I show, you see the two payments on the 18th, right?
I see $200 about into this case on the 18th, is the
Yeah.
only thing that I see. And there was no money applied so far that I can see in the Walton County case.
So, you know the way the system works, it works on what the records show. And if you made your payments and you can get a receipt, because if you did it online, there'll be a receipt for however you did it online. Get that receipt, show it to probation, or provide it to the state to show where the payment was made. And I will tell you, sometimes the payments go somewhere because they weren't properly, you didn't have the proper case number or whatever. So, but get that receipt and show. We'll set this on 4/17
Okay.
for you to get all that stuff together. You also got to show probation that you completed your community service hours. Just doing them and keeping the paper doesn't fix it,
Yeah,
right? You got to show them. So get that all done, and we'll see you back on the 17th. And if it's all squared away, then you heard what the state's going to do.
Okay.
They're going to dismiss the VOP and let the case terminate, okay?
Ms.
Okay.
Howell looked it online, and it showed that I did have it all paid off. She told me that if I get it done before I come to court, just bring the paper up here.
Right.
It showed that he paid the monies through correct pay, but apparently it hasn't made it to the clerk yet.
Oh, so he didn't pay the clerk, he paid correct
Yeah.
pay.
Yeah,
Yes,
there's a
sir.
difference. Yeah, it went in our system, but apparently they haven't received it yet, because it's still showing a balance on the clerk.
Correct. So that's different. You didn't pay the clerk, you paid
Yeah,
corrections.
correct pay.
Right. So that takes sometimes up to 7 days for it to hit the clerk's office.
Oh.
Okay? So we'll see you back on the 17th if it's all done, and let your officer know, and you've heard what the state was said, that they'll dismiss the VOP and let the case terminate.
All right, thank
Okay?
you.
All right, thank you now.
Thomas Cruz. Dominic Cruz, my apologies.
Dominic Cruz.
Yes, sir.
All right, you're here today without a lawyer. Do you want a lawyer to help you, or you want to hear what the state has to say?
I want to hear what the state has to say.
Okay.
This time, it's an either-or offer. If he wants to be free from probation, it would be a 90 days in the Okaloosa County Jail, admit the violation, revoke and terminate supervision. If he doesn't, we would modify supervision for the next 6 months to be on community control, followed by the remainder of supervision to be on standard probation, Your Honor.
I have one question, sir. What is community control?
Community control is a stricter form of supervision.
Yes, sir.
It requires you essentially to make a schedule of where you are and what you're going to do for all the time.
Yes, sir.
And you have to follow that schedule. And if you want to deviate from that schedule, you have to report to probation and tell them why.
Yes, sir.
If it's a legitimate emergency, they provide you information about that.
Yes, sir.
So that's community control, and I explain it this way. If my wife says, oh my goodness, we forgot to get milk, I can get up at 11 o'clock and run out and get milk. You can't,
Yes, sir.
Or early in the morning, if I decide that I'm going to treat my wife to a fresh coffee from Deb's Coffee, I can do that. You can't.
Yes, sir.
Right? So it's a difficult thing to do. It's very strict on what you have to do and what you can't do.
Yes, sir.
And so that's community control.
Yes, sir.
And Your Honor, just for the court's awareness, we would modify to add 6 months. He has terms, so we would have to add 6 months from today's date. He would be on community control for 6 months, and then probation would terminate.
All right. Are you willing to do that, or do you want a lawyer to help you?
Can I get a public attorney?
Yes, sir. You'd have to complete the application. The application will be given to you now, that you complete the application, and then don't leave until you turn it in and get a new court date, okay?
Yes, sir. Thank you.
All right. All right, then I show William Glasper. William Glasper.
I'm sorry, 26 through 30 in the feet, you can start with the feet.
And we're going to take a 5-minute here. Are you William Glasper?
I'm the bail bond.
On Mr. Glasper?
Yes, sir.
Okay.
I had put in a motion, I'm here on case number that's 2020 CF 1120, and I have an order on a motion to set aside the forfeiture and cancel the bond.
Okay.
I put the order in and waiting for your signature, sir.
All right, what's the state's position on the bondsman's request?
State has no objection, Your Honor.
All right. And you say, did you submit an order already?
Yes, sir. I have
And
a
I
copy.
think I reviewed this and said, because of the circumstances, I required the state to either concede the motion as required by the statute or not. So let me just double check and get that order in front of me, and I'll sign it right now. Give me just a second. All right, it's signed, and it should be processed by the clerk shortly.
Thank you very much.
Thank you. Good day. And issue a no bond capias for Mr. Glasper. All right, and we're going to take a 10-minute recess. Y'all get your folks lined up and let me know about Mr. Trell as well, okay? 10 minutes.
All right, please.
10 minutes.
Judge Stone's in a 10-minute recess.
It's not.
Judge Stone's in a 10-minute recess.
No, it's on his phone. He literally just put his phone. Yeah.
Status. Yeah, Lynn, I'll be right back. I got you.
So you just gonna stick with the report to DDP?
Yeah, if I don't.
in Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Do this. If the clerk says you don't qualify, they'll tell you why. If you think the clerk's wrong, get everything you have that shows the clerk is wrong, give it to your lawyer and bring it to court with you next time.
Mine?
Yeah, I'm working with you.
And you heard the state's offer, Mr. Kleins?
I did, Your Honor.
All right.
Your Honor, if we could enter denial today, I'd ask that this be set without subpoenas for the first available date in April.
All right, Madam Clerk.
April 17th.
April 17th, denial's entered. All right, Dominic Cruz.
Is that a 6?
Yeah.
April 17th.
All right, the amount you listed here, is that what you take home every 2 weeks?
Oh, I meant to put, that's monthly. I meant to put monthly.
So that's monthly, that's not
Yes,
every
sir.
2 weeks?
Yes, sir.
And that's what you take home?
Yes, sir.
All right. Looks like you qualify. I'll appoint the public defender to represent you. As I said, the clerk will review this. If they say you don't qualify, they'll tell you why. If you think they're wrong, get everything you have that shows they're wrong and give it to your lawyer and be back and bring it with you to court next time. Dominic Cruz.
Yes, sir.
Judge, at this time, we'll be entering denial. If we could have this set for the, I believe that 4/17 date without subpoenas.
All right, 4/17.
Excellent. I'm going to talk to you too.
Thank you.
You're welcome.
You have a good one.
Thank you, Judge.
All right. Mr. Trell, are you ready?
Yes. I am ready, Your Honor. May I cross the bar and enter the well, Your Honor?
Granted.
Yes.
Judge, just for your awareness, Mr. Cobb let me know that he's logging back onto Zoom right now.
Yeah, okay. So it's going to be, and there.
Guess I'll be using Uber for staking.
Yes.
Today's date?
Today is the 20th. All right. And, Your Honor, if I could, I'm going to retain the written plea for a moment to announce from because I've aged a much, so I can't remember all of this. Your Honor, we are withdrawing our previously entered denial, and we are entering an admission to the VOP. We have an understanding that there will be an adjudication of guilt on the VOP. We are reinstating his probation and modifying probation to community control for 2 years. Then he will finish on the original terms and conditions. And his original terms and conditions are a sex offender probation, and that will apply for the then unexpired term of probation, whatever it is, whether it's 2 days, 2 months, whatever that is. We are waiving the pre-sentence investigation, and we are stipulating to the score sheet. And may I approach with the signed plea, Your Honor?
Granted.
And I believe there's one other issue, Your Honor, is that he will be on a GPS hold until they can get the GPS reinstalled.
That's correct, Judge, and it is a downward departure based on negotiated plea.
All right, downward departure made legitimate, of course, plea.
Yes,
Okay.
Judge.
All right, raise your right hand for me, please, Mr. Wood. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, I do.
All right, and you put your hand down. You heard what Mr. Trell announced on your behalf and signed the written plea form.
Yes, Your Honor.
You understand that you're admitting the violation.
Yes, Your Honor.
And that says, Judge, I admit that I violated my probation just the way the affidavit report said it did.
Yes, Your Honor.
Okay. You understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
In this case, you've already been adjudicated. You'll be reinstated to your probation with a modification to community control for 2 years, then finish your original terms and conditions well, he'll still have the special conditions while he's on community control, right? That's
Correct.
not changing, but when he reverts back to probation, he'll still have the special conditions.
That is correct, Your Honor.
Okay. All right, so there's no confusion about that. All those special conditions still apply, but with the addition of the community control sanctions, correct? All right, for 24 months from today. And then $100 cost of prosecution in this case as well.
Yes, Your Honor.
All right. Court find the plea to be freely and voluntarily entered into and will accept the plea.
Thank
All right.
you, Your Honor.
Thank
That's all
you.
I have before the
Thank you,
court.
Mr.
May it be a
Trell.
good
Good
day. Thank you, Your Honor.
Thank you.
Thank you, sir. Good day.
Amanda McFadden with Mr. Klein.
Your Honor, this is Ms. McFadden. She is going to be signing a plea agreement here, resolving these violations. The agreed upon disposition upon, she is going to admit the violations. The agreement between Ms. McFadden and the state is that her supervision in all 3 cases will be revoked and terminated. She will be sentenced to 90 days in the Okaloosa County Jail. That's with credit for all time served, concurrent between all the cases. She will be assessed a $100 cost of prosecution for each one of these cases, a $100 public defender, $100 public defender fee for each of these cases. There will be one $50 application fee. She has previously been adjudicated. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you heard what Mr. Klein said. You signed the written plea agreement.
Yes, Your Honor.
All right, you understand you're admitting the violation.
Yes, Your Honor.
And that says to me that you violated just the way the affidavit report says you did.
Yes, Your Honor.
Okay, you seem reluctant. Do you not agree to that?
I did kind of understand what you said. He said,
He's basically saying that you're admitting that you violated.
Oh, yes, Your Honor.
Okay, all right. And do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove that?
Yes, Your Honor.
In this case, you'll be adjudicated guilty, 90 days county jail, credit for all time served, and you'll have some fees and costs that you'll have to pay. And you also have some outstanding fees and costs that, in all 3 of those cases, that you're going to have to pay, right?
A year, yes, Your Honor. Up to a year, please.
She's respectfully requesting a year, Your Honor.
Yeah, and as long as you're making payments, is if you need more time than that, just ask and I'll provide you additional time. The goal is to get them paid. So if you're paying, I'll give you time, but if you're not paying, don't bother asking. I won't give you any more time. You understand?
Yes, sir.
Okay. Court find the plea to be freely and voluntarily entered into and will accept the plea. Mr. Cobb's next with Mr. Powell. Okay?
Mr. Powell, the liquor.
All right. Good morning, Mr. Cobb.
Good morning, Judge.
All right, we're ready to proceed with Mr. Powell.
Yes, sir.
Go ahead.
Judge, this is State versus Quentin Powell. I don't have the case number right here with me, but he had filed a letter to the court, and although it wasn't styled as a Nelson hearing, he did raise his desire to have a new attorney based on my ineffective assistance, and the court set this for a Nelson hearing. When I got a copy of Mr. Powell's letter, I was taken back because I thought that the investigator that I had appointed had been out to see him with the discovery and gone over it. But I can tell you that in between the time that I received that letter and now, I know for certain that the investigator went out and met with Mr. Powell at the jail and reviewed all the discovery with him and watched every video that the state provided in discovery with him. Also, I had emailed him a paper copy of all of the discovery, and I went through and watched every video and wrote a detailed memorandum describing exactly what the contents of each video contained, and that was mailed to him at the jail. So as far as the discovery aspects of this case, I'm confident Mr. Powell has, in fact, seen all the discovery that the state has provided in this case.
All right. Mr. Powell, what is your desire at this point in time?
I let them stay on my case now because they came up afterwards. After I filed a motion, he came and the investigator came up there and talked to me, so it's just he was moving too slow.
All
I've
right.
been in county jail 17 months.
Okay. So what is it that you want me to do?
It doesn't. He can stay on my case.
Okay. All right. All right. So at this point in time, the Nelson is resolved at this point in time, and I see that we're currently set for the 310 pretrial conference, right?
Yes, sir, that's correct.
Okay. All right. Thank you very much. Thank you, Mr. Cobb. Good day.
Thank you, Judge.
Your Honor, this is Mr. Herman Bennett.
And Madam Clerk, I'm showing that there's active process. Why is that showing on this case?
May I have the name?
Herman Beck?
I can maybe fill the court in a little bit, Your Honor. Yesterday, Mr. Beck was arrested based on a warrant out of an incident that occurred in November of last year. That case is 25 CF 357. That case is currently in Division 1, so it might be an active process for service of a new violation.
In order commanding arrest.
Okay. So, yes, it looks like on 220, the order commanding arrest was. Okay, that was the result. Okay. That order came out as a result of the first appearance, where the first appearance judge
Probably revoked bond.
revoked, actually did a VOP on these three cases based upon the new charge. So, and I guess technically we can't have him served because it's not yet in the sheriff's system, so it'd have to run through the system to get him served. But and so Mr. Beck, Mr. Kleins will explain to you, whenever I see something like that, I want to be sure we get all the pieces moving in the right direction because I want to be sure everything's taken care of. And that's the reason I asked the question.
Absolutely. So, Mr. Beck, what's going to happen is probably tomorrow or maybe the next day, you're going to go through first appearance again. Okay, so, Your Honor, so I looked at the arraignment date in 25 CF 357. I've done a good amount of work on Mr. Beck's cases. I believe, actually, I should say, that the traditional process is that these VOPs would then be transferred to Division 1. I would request if the court would allow me to transfer the new law violation to this court so that hopefully we can get some kind of a resolution. And my intent would be to ask the court, I don't know why his arraignment is April 17th on that case. I was going to ask the court if the court would allow us to transfer that new law violation into Division 2 to move his arraignment up to March 13th.
So I show it is in Division 2.
Perfect.
I see Mr. Medina was assigned, and I think that's incorrect.
Okay.
It is in Division 2.
Awesome. But can we put him on the April 13th? Or, I'm sorry, the March 13th arraignment docket?
Any objections, State? Move the case up, that's what I say.
Yeah, no objections, Your Honor.
All right, yeah, it is assigned to this division, I just checked. So we'll move the arraignment up to 313. That's going to put a little heat on you to get the information filed. Let's have the 3 VOPs travel with it, so set those 3 VOPs on 313 as well. So in the event that we have some resolution, they'll all come together.
I can fill Mr. Gomez in. Just briefly, Mr. Gomez, this was a traffic stop on November 21st. The reason why he was recently arrested was that's when the FDLE report came back. So there should already be FDLE.
Okay.
All right, so I guess in an attempt to save resources and time, how can we deal with these 3 active? There's no reason for him to go through a first appearance again on those.
What I'll do is, as soon as I have a moment, I will email Major McDaniel up at the jail and just advise her, like, can we move this up so Mr. Beck can have this active process resolved?
Okay. So, you see where I'm coming from. And your client has a big question mark on his face, but the goal here is to be sure to save time and move the cases forward, because I don't want something else to happen and have it trip up and not have the cases move forward.
Yes, sir. I'll communicate with Major McDaniel today.
Okay, all right.
Okay.
So we'll move all 3 of these to 313, and actually,
I appreciate that, Your Honor.
because well, hold on just a second. He's already here on a violation status, right?
Right. I mean,
so why would we even need the 220 order anyway? Revoking and commanding arrest, because he's already here on a violation status. Mr. Gomez, couldn't we just revoke that order and,
I would have no issue with that, Your Honor.
well, because we've got the, I guess, well, hold on, let me check and see if there's a warrant in his queue. $21,251. $21,251. Because I see the report, but I don't see a warrant. Do we know if a warrant's been tendered from y'all on the amended report? It doesn't look like I've got a warrant yet, Mr. Klein, so let's just leave that and let that process play out so that there's no confusion about his detention status. But I guess we're here anyway because of the...
Well, the reason why he's on today's docket is I had passed him from last Thursday, hoping to get a resolution here, and then hit the speed bump yesterday. So...
Okay.
That's why he was on today's docket. He was here last week when he was out of custody. And he was on today hoping to get something resolved.
And so the
here.
addendum follows his case from last week is what we're saying, right?
I'm showing a order commanding arrest that was signed by Judge Mason on the 19th.
Correct. But the addendum report says that a warrant is being requested as well. And see, that's my concern. I don't want...
I get it. I mean, I don't know. I typically don't get involved in the weeds like this on I don't even know what Your Honor's looking at, but if the court could just order his bond to be revoked, I don't know if that would short circuit everything else, and I mean, it would.
In the new case, you're saying?
Well, no, not in the new case, in the VOPs. I mean, his bond was already revoked, I guess, at first appearance, so when I say I don't really get involved in I don't really look behind the curtain to see how warrants are served and how they move through the system. I mean, that's...
Because his violation goes way back, right?
It does, Your Honor. I mean, and this is a situation where, in full candor, Mr. Beck has a suspended sentence on him. In the past couple of weeks, I have provided reciprocal discovery to the state of all sorts of different character letters and certificates of completion. He completed Phoenix House. So that's why I had passed it over to this week to hopefully see if all of that mitigation had kind of swayed the state to more favorable resolution than seeking the suspended sentence.
Okay. All right. So I've made some notes here. We'll address that. If you would reach out to Major McDaniel.
Sure.
I think the order commanding arrest will take care of that.
Okay.
Then with the addendum report, that should activate that without the necessity of the other warrant. I want to be sure that we don't cross over and have to do this twice is all I'm saying.
As soon as I'm done with my morning docket, I'll email her.
All right. All right. Very
I'll
good.
go see you at the jail.
All right.
Your Honor, this is Mr. Martin in 23 CF 543. This is his arraignment. We will enter a denial today I did talk with Mr. Gomez. The allegations are that he basically hasn't done his DUI minimum requirements, and he has not reported. Mr. Martin, may we approach briefly?
Granted. All right, we'll have his prints taken now. That's one of the conditions of probation, release him on $1,000 signature bond. You're going to provide that order, Mr. Klein?
Yes, sir, Your Honor.
We'll
I'll
put
have
that in the minutes so he can do it now, but you get me a separate order.
Yes, sir, I will.
For that.
All right, they're going to take your prints now to clear up any confusion about the prints, but get on this stuff, all right? All right, yep. And the next court date, Madam Clerk, would that be April 17th?
Yes.
Yes.
Jason Morrison?
Your Honor, this is Jason Morrison in 23 CF12. I talked to Mr. Gomez. Mr. Morrison is actually on supervision out of the state of Alabama for the exact same grand theft auto that he's on probation for here. We did confirm with Fayette County probation this morning that his termination date is in May of 2027. Given all of that, and the fact that Mr. Morrison spent 13 months in county jail up there before being placed on probation, I believe the state would have an announcement here.
Yes, Your Honor, at this time, we're going to be dismissing the violation of probation and terminating supervision. This defendant is on probation for the same offense in Alabama. And so for that reason, Your Honor, we're going to allow him to finish his time out in Alabama, take him off the probation's docket or list, and terminate his supervision, Your Honor.
All right, VIP is dismissed, supervision is terminated. Are there any outstanding financials?
Yes, Your Honor, there's outstanding court costs, there's outstanding costs of supervision. I would ask the court to give Mr. Morrison a year to pay his financial obligations here.
All right, I'll provide him a year as long as you're making your payments. If you need more time, you can ask for more time, but don't ask for more if you're not making payments, okay?
Supervisor Basalmi.
All right, all right, thank you now, good day.
Jason Neely?
Your Honor, this is Mr. Neely. Can we pass Mr. Neely's case to the 1:30 docket? I'm trying to hopefully get a resolution with Mr. Gomez here today. I don't want to just...
Were you able to keep Mr. Neely to the 1:30 docket? Yes, we'll pass him 1:30.
Your Honor, next we should have Angela Robinson and Mr. Cox. Angela Robinson, right, please?
This is Angelica Robinson in 2020 CF 1352. And Your Honor, if I may have a brief moment.
Yes, sir.
Yeah. Judge, this will be an admission this morning. This will be an adjudication of guilt. I just do want to notate that both counts 1 and 2 are misdemeanors, but this will be an adjudication of guilt, 160 days in the Okaloosa County Jail. There's $100 cost of prosecution, $150 defense costs, course credit for time served. Probation will be revoked and terminated. All counts run concurrent. And Judge, I did notate on the plea form, we had a last minute change to the 160 days, so I scratched out the number. I did have my client initial by it. Just wanted to notate that, if I may approach.
Granted. Court costs.
The 100 prosecution and then 150 PD.
Yeah. Now, are there other outstanding financials, and how much time would your client need to get those squared away once she's released?
You could ask the judge.
May I have a year, please?
Yes, ma'am.
Thank you.
And as long as you're making the payments and you need more time, you can ask for it and I'll give it to you, okay?
Okay, quick question about the payments. Is that a certain payment amount each month or just
No,
paid by the year?
ma'am. You know, I would say that you should look at it and divide by 12 and do your best to get it done. You know, I don't know the total amounts that are outstanding. I can give you an estimate here. Madam Clerk, what do you show outstanding?
Let me add. So I show about almost 1,800.
It's $1,800 outstanding.
Okay.
Was a year enough? You need 18 months.
I'll take the 18 months, please.
Okay. All right. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
Do you understand you're admitting the violation?
Yes, sir.
And that says to me that you agree that you violated your probation just the way the affidavit and report says you did?
Yes, sir.
Do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you'll be sentenced to 160 days in the county jail, credit for time served. You'll be adjudicated guilty. Your probation will be revoked and terminated. And you'll have the fees that were announced, and you'll have the 18 months to get all your outstanding financials paid.
Okay. Yes, sir. Thank you.
All right. I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you.
Next will be Heather Roberts.
Judge, this is Miss Heather Rogers in 22 CF 2237, 23 CF 2123, Your Honor. Judge, this morning we'll be entering a denial and requesting this be set to the April 17th without subpoenas. Just to make the court aware, my client, the new law violation is in 25 CF 206. Attorney Jason Cobb is assigned to that case. So this morning, we did file a motion to withdraw. I spoke with Ms. Jaquette, and she's aware of the 4/17 date to get that pushed through, so ultimately Jason Cobb can be appointed.
All right, and so when is the new case set for hearing?
The arraignment date, Judge, I don't have that in front of me, the 25 CF 206.
I show it as in Judge Clark's division.
It's in Judge Clark's division.
I was unaware of that. I do know Jason Cobb is the attorney assigned to that, Your Honor.
Okay. Well, we'll set this on 4/17. If the defense and the state wish to make the transfer, they can do so.
Okay, yes, Your Honor.
All right, denial is entered in 4/17.
So I'm still your attorney. We entered denial, but ultimately I'm withdrawing from these cases, and we're getting the motion set. Okay?
So what do I do about the violation?
Well, we don't make any statements. We just entered denial today, but ultimately Jason Cobb's going to come talk to you about everything. Thank you, Judge. This is Miss Megan Scholes. We're here on 3 case numbers, 23 CF 2301, 23 CF 2426, and 23 CF 2823. Your Honor, this will be an admission this morning to the violations, and of course it'll be adjudication of guilt, 180 days in the Okaloosa County Jail with credit for time served. There's $300 for the cost of prosecution, $350 for defense costs. Probation will be revoked and terminated. All counts and cases to run concurrent. If I may approach with the plea form, Your Honor.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf. You signed the written plea form.
Yes.
You understand you're admitting the violations.
Yes.
And that says to me that you agree that you violated the way the department says you violated.
Yes, sir.
You understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
In this case, you'll be adjudicated guilty, and you'll serve 180 days county jail, credit for all time served, plus the additional fees and costs that were announced. Your probation will be revoked and terminated. You've got some outstanding fees and costs, I believe. How much time do you think you'll need to have to pay those off when you were released?
How much time?
Possibly a year.
You can ask for a year.
A year, maybe?
Okay. Yes, ma'am. I'll provide you a year to do so, and as long as you're making the payments, if you need more time, you can ask for more time. But don't bother asking if you're not making the payments. The goal here is to give you the opportunity to pay, and if you're making the payments, I'll give you more time to do so, okay?
Can I get a total number of what I owe?
Madam Clerk, we can give you an estimate right now because, you know, ordinarily, she have any outstandings, what we got from probation?
She's got 665 on one case, 615 on the other two cases, and the rest of it will be closed because she's been revoked.
Plus the 650 from today.
Yeah.
So, I'm not really good at math, but it sounds,
$2,545.
I was gonna say about $2,500.
Okay.
Is a year long enough?
Can I ask for a year and a half?
Yes, ma'am, you can. And once again, if you're making the payments and you need more time, my goal here is to motivate you to pay. And if you're making the payments, then I'll give you the opportunity, okay?
Yes, sir.
Okay. Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you.
Did we take care of Haley Lewis?
No, sir.
We did not, Your Honor. That was a C4 motion that we.
Okay, well, I just, it was on my list. We'll get, I just want to be sure. We'll get back to that.
Judge, this is Mr. Jacob Riggs in 24 CF 1118, 24 CF 1172. If I may have just a brief moment, Judge.
Yes, sir.
Thank you, Your Honor. Mr. Riggs will be admitting to violations, Your Honor. This will be an adjudication of guilt. 9 months in the Okaloosa County Jail with credit for time served. There's $200 for the cost of prosecution, $250 for the defense costs. Probation will be revoked and terminated. All cases and counts to run concurrent. If I may approach the signed plea form.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
And you put your hand down. You heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes, Your Honor.
Now, you understand you're pleading, you're admitting the violation here.
Yes, Your Honor.
And that tells me you agree with what the department said that how you violated your probation.
Yes, Your Honor.
You understand you're waiving your right to a hearing where the state would have to prove that.
Yes, Your Honor.
In this case, you'll be adjudicated guilty, do 9 months county jail, credit for all time served. You'll have the additional fees and costs. Your probation will be revoked and terminated. You've got some outstanding fees and costs in this case. How much time will you need to pay those after your release?
Depending on the amount, probably a couple months at least.
How much do we show he has outstanding?
$765 on one case, $715 on the other.
All right, so $1,800 plus the cost today, so you've got, you know, just over $2,000.
At least 6 months.
Realistically, you can do that in 6 months?
You could judge you if you need a year to pay.
I mean,
Once you make the payments, though.
I want you to succeed in making the payments because there's adverse consequences for not doing it. My goal is to be certain that we collect the money that's appropriate. So if you need more time, I'll give you more time because my goal is to get you to make the payments. That's what I want to happen.
2,000.
Is a year sufficient, you think?
A year and a half.
You know, okay. You want a year and a half?
Yes, Your Honor.
Okay. 18 months to pay. And if you're making the payments and you need more time, you can ask for more time as long as you're making payments, okay?
Yes, Your Honor.
All right. Court will find the plea to be freely and voluntarily entered into and will accept the plea. You're welcome.
This will be Willie Mac Patterson.
Your Honor, this is Mr. Willie Patterson in 23 CF 1261 and 25 CF 173. If I may have a brief moment, Your Honor. Judge, Mr. Patterson, we'll begin with the 23 CF 1261. Counts 1 and 2 will be admitting to the violations. Be adjudication of guilt, 11 months, 29 days in the Okaloosa County Jail with credit for time served. There's $100 cost prosecution, $150 in defense costs. Probation will be revoked and terminated. In 25 CF 173, counts 1 and counts 2, this will be adjudication of guilt, 11 months, 29 days, Okaloosa County Jail with credit for time served, $615 in court costs. There's $100 in defense costs. All cases and counts to run concurrent. If I may approach with the signed plea form and no objection to the score sheet, Your Honor.
That's the state's agreement.
That is, Your Honor. And it is a downward departure for the purposes of legitimate uncoerced plea bargain.
All right, Mr. Patterson, if you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Koch announced on your behalf and signed the written plea form.
Yes, sir.
How old are you and how far did you go in school?
I'm 61. I went to 11th grade.
Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
All right. Now, you've got two things going on today. We're taking care of them together. You got your new charges and you got your VOP, right?
Yes, sir.
Now, as far as your VOP, do you understand that you're admitting the violation?
Yes, sir.
And that says to me that you agree with what the department said about how you violated your probation.
Yes, sir.
All right. Do you understand by making that agreement that you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
Now, as to your new charges, do you understand that you're pleading no contest to those charges?
Yes, sir.
And by pleading no contest, what I understand you to say is that you believe the state's got the evidence to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial where the state would have to make that proof?
Yes, sir.
All right. In this case, you're going to be adjudicated guilty. Your probation and you'll be revoked and terminated. You're going to be sentenced in both cases concurrent to 11 months, 29 days in the county jail, credit for all time served with the fees and costs that were announced.
Yes, sir.
You also have some outstanding fees and costs in your probation case.
Yes, sir.
Now, once you've finished your time, how much time do you need to get all those fees and costs paid?
6 months. Could I?
Your Honor, if I may, my client does have some medical issues. I know he's concerned with once he's released. Could he ask for a year and a half once he's released from the county jail?
That's fine with the court. The goal here is to provide you the reasonable opportunity. You know, if you see 6 months and you know you can't do it, the chances are you're not going to try. But if you see a year and a half, my goal here is to encourage you to make the payments because that's what I want you to do. So is a year and a half give you some breathing room where you might be able to get it done?
Yes, sir. Well, why I said that because I was going to file my taxes. I hadn't.
Okay. All right. So I'll give you a year and a half to pay.
Yes, sir.
And if you need more time, as long as you're making payments, then I'll provide you additional time to make those payments. Now, with all of that, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. Koch has represented you in this case?
Yes, sir.
All right, I'll find the plea that's freely and voluntarily entered into, and I'll accept the plea with the adjudication on the, he was previously adjudicated on the VOP and the new adjudication on the new cases. Thank you, Mr. Patterson.
Jared Smith.
I got documents prepared for this case. Gotcha. Judge, it's Mr. Jared Smith, 24 CF 2536, Your Honor.
And this is...
Correct. I don't want you making any statements.
All right, well,
Because everything's on the record.
all right, well, I'm willing to, because I did not even...
Okay. Judge, I believe my client, I guess, wants to relieve the public defender's office. I'll let him.
I don't necessarily want to relieve the public defender's office, but to my understanding, I'm still defending myself as of the time being, because the appointment of the public defender's office was done without my consent or knowledge. But I have a couple documents that I want to file into the case. I have a C4 motion to dismiss here for case CF 188. Can I continue oratorily, Your Honor?
Okay. My understanding is the public defender was appointed to represent you in the VOP case at your first appearance.
I did not make it to first appearance, Your Honor. So it was done without my knowledge or my consent. So I would like to continue with my motion to dismiss for 25 CF 188, please.
We're not here on 25 CF 188.
To my understanding is that the violation of probation is for the new law violation of CF 188.
Yes, sir. We're only here today on 24 CF 2536. We're not here on the other case.
Yes, Your Honor. Well, I would like maybe to speak with the public defender's office if today we're not talking about CF 188.
No, we're only talking today about the violation of probation, and the violation of probation is...
Solely hinges on CF 188. So if the violation solely hinges on 188, then I don't know what else to do other than question the viability of case C188.
.25 CF 188.
180A is what my paper says here. I was actually informed yesterday by letter that the public defender was issued to my case. So he just showed me a paper, it says CF 188.
Slow down, let me get to the case.
Yes, sir.
And see what it is. I just want to be sure I understand what's going on here.
And I do believe...
Hold on, let me look at the case first before you... I can't listen and read, okay? So slow down. Let me see what I can see here, okay?
Yes, Your Honor. My apologies.
And once again, we're here only on the 256 case today, which would be based upon the VOP, and it's here for arraignment on the VOP. Now, do you wish or not wish to have the public defender to represent you in this case? I've reviewed the first appearance paperwork, and the way the public defender was appointed to represent you is it appears from the first appearance paperwork that you refused to attend first appearance twice in a row, and therefore the judge holding the first appearance appointed the public defender, as is our standard practice. If you do not wish the public defender to represent you, then you're free to represent yourself. If you wish to accept the appointment of the public defender, that is acceptable as well.
As far as the public defender is concerned, I would wish to file these documents into the case CF 180A if the public defender does actually want to look at them and tell me what he thinks, please. I mean, that's up to him. I will give him a copy of the paper right now. I prepared copies for both the public defender or for the state's attorney and you, because I was not aware until yesterday that I was being represented by the public defender.
Okay. Well, so you wish to provide these documents to the public defender and ask the public defender to represent you in the matter? Is that what you're asking?
I will, can I still retain the right at any time to represent myself once the public defender?
Absolutely. Everyone has the constitutional right to represent themselves.
Okay, so I will accept the help of the public defender in this situation, Your Honor.
Okay, all right. So, Mr. Koch. All right, and Mr. Koch, I show the 180 case is set for plea arraignment on 3/13, and so you're here today for arraignment on the VOP. Do you want to enter a denial on the VOP, then have a chance to talk to your client, review the paperwork he's had, and if you need to advance the 3/13 date, you can do so?
Yes, Judge.
Okay.
And if I may, Your Honor, just put something on the record.
Yes.
I spoke with Mr. Snell yesterday, and just seeking an offer. Currently, my client scores roughly 39.5 months, Department of Corrections. So, of course, that's why we're entering denial this morning, Your Honor.
Okay, so the state's offer is a guideline sentence offer?
Yes, Your Honor.
Okay, all right. So, and that's not to say that's what it would be, but Mr. Koch is doing what I asked, which is to announce any offers on the record in open court so it's clear that it's communicated effectively.
Right,
So communicate with your client, and we are set for 3/13. Madam Clerk, I want you to attach the 24 CF 2536 to the 180 case so that they'll appear on the arraignment docket. If you need to advance it for any other reason, Mr. Koch, you can ask that it be advanced after you have the chance to chat with your client.
Yes, Judge.
Okay?
Thank you.
All right, thank you very much.
Judge, this is Mr. David Roberts, 24 CF 2086, Your Honor.
Yes.
We are here for a competency status.
All right.
Judge, were you provided a copy with that recent evaluation?
Yes, I have received and reviewed the report from Dr. Klein, which says the evaluation was completed on 1/13 and report on 2/4 and then filed on 2/17. Is that the one you're referring to?
Yes, Your Honor.
All right, and that's the updated one we requested, right?
Correct, Judge.
And what's the state's position on the report?
Judge, we have reviewed Dr. Klein's report also, and we would have no objection to the court considering it or finding Mr. Roberts incompetent due to intellectual disability and committing him to the DDDP program.
All right. The court accepts the reports and the stipulation of the state and determines the defendant is not able to proceed at this time and commits him to the the DDP program, and you'll provide an appropriate order.
Correct, Judge.
All right.
Defense will provide that order.
Thank you very much.
Yes.
Mr. McKinney.
Yes, Judge. Good afternoon.
You've been to this all whole lot.
Yeah, I always do that.
Did you have a chance to read it over? Do you have any questions? Judge, we have reached an agreement. Madam Clerk, this is also going to resolve 25 CF 16, which is a new law offense. It's 2/2025.
126, you say?
16, which is a new law, one count grand theft.
Okay.
The agreement that's been reached with the state is for a plea of no contest in 25 CF 16. As charged, adjudication would be withheld. She would be placed on 3 years of probation concurrent with case numbers 24 CF 2594 and 23 CF 1508. Special conditions would include an anti-theft course, substance abuse evaluation and treatment, random urinalysis, $799 in restitution to Cash American Pawn, $515 in court cost, $150 cost of defense. In each of the 2 felony violations of probation, there would be a continued withhold adjudication and reinstatement of her probation to complete the original conditions, plus a $200 VOP fee and a $200 cost of defense. May I approach with the plea agreement?
Granted. Is that the state's agreement?
That is, Your Honor.
And is a guideline sentence?
It is, Your Honor.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay. You can put your hand down. You heard what Mr. McKinney said and you signed the written plea form?
Yes.
How old are you and how far did you go in school?
I'm 26 and I finished up until the 11th grade.
All right. You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And is what you read what Mr. McKinney just announced to the court?
Yes.
And you got 2 things going on. You got your new charges and you got your VOP, right?
Yes.
As to the VOP, you understand that you're admitting the violation?
Yes.
And that says to me you agree with what the department says as far as your violation?
Yes.
Do you understand by making that admission you're waiving your right to a hearing where the state would have to prove you violated?
Yes.
Okay. Now, as to your new charges, do you understand you're pleading no contest?
Yes.
By pleading no contest, what I understand you to say is that you believe the state has the proof of your guilt and you're not going to contest that.
Yes.
Do you understand by making this plea you're waiving your right to a trial by jury?
Yes.
All right, in this case, on the VOPs, you're going to be reinstated to complete your original terms and conditions. On your new charges, you're going to be on 3 years probation, concurrent with your 2 existing cases, with the special condition of the anti-theft course and then the random testing and any recommended treatment. And you'll have the restitution to pay in addition to the court costs that were announced. Is that what you understood?
Yes.
Mr. McKinney answered all your questions about the plea and how it affects you.
Yes.
You're satisfied with what he's done for you?
Yes.
Okay. Court will find the plea to be freely and voluntarily entered into and accept the plea with the adjudication.
You're good. Good. Talk to probation on the way out. To withhold.
I'm sorry, it is withhold. I apologize. Withhold.
Jillian Watson.
Let's walk. Walker. TJ. Bring her back.
Hey, you're good. Do you have any questions? This is Jillian Watson before the court. He's here for violations of probation, 2 case numbers. We've reached an agreement with the state. The agreement that's been reached is for an adjudication of guilt. Previously, this was a withhold. I've explained the consequences to Ms. Watson. The sentence would be 180 days Okaloosa County Jail with credit for time served, revoking and terminating her probations. She specifically is not going to get credit for any time spent in the Keaton program as part of this agreement. It is only going to be jail time. I've explained that to Ms. Watson. But that is how we reached this agreement, because this is a negotiated downward departure as well. $100 VOP fee in each case, a total of $250 cost of defense. May I approach with the plea agreement?
Granted. This is a guideline sentence?
This is going to be a negotiated downward departure.
All right. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand that you're admitting the violation?
Yes, sir.
And that tells me you agree with what the department said regarding your violation?
Yes, sir.
And you're waiving your right to a hearing where the state would have to prove that?
Yes, sir.
Now, one of the material agreements here is that you're getting no credit for the time you're in Keaton.
Yes, sir.
That's a significant waiver of your legal rights. Do
Yes,
you
sir.
understand that?
I do.
You're only getting credit for the time you spent in jail, not the time while you're in Keaton.
Yes, sir.
Okay? And so it's 100 adjudication of guilt, 180 days in the county jail, credit for the time served only in the jail, revoke and terminate your probation with the fees and costs, the additional fees and costs were announced. You have some outstanding fees and costs as well. How much time do you need to get those paid after your release?
Since leaving Keaton, I restarted at the Oxford House, sober living, so if you don't mind having to start all over, if I could get maybe a year to get that paid off?
Yes, ma'am. I'll give you a year, and if you're making your payments and you need more time, ask for it and I'll provide you time. The goal is to provide you the opportunity to pay.
I appreciate
So if you're making the payments, I'll provide you additional time.
Yes, sir.
And Judge, part of the outstanding costs are cost of supervision. Would the court be inclined to
I'll
waive the cost of supervision in the
under the
rearages?
circumstances.
Thank you.
Okay?
Thank you, I appreciate
I'll
that.
find the plea to be freely and voluntarily entered into, and I'll accept the plea. She was previously adjudicated.
It was previously a withhold. This is an adjudication of
Okay,
guilt.
so we'll need prints.
Thank you.
Jamie Wiggins.
Ms. Wiggins is before the court in 2 case numbers, 24 CF 10 and 23 CF 2778. As part of the agreement that we've reached for the violations of probation, this also will include a plea of no contest to a misdemeanor case, which I've informed Madam Clerk, is 25 MM 212, which is a one-count possession of paraphernalia. The agreement that's been reached with the state is for Ms. Wiggins to admit the violations of probation, for her probations to be reinstated to complete the original conditions, keep the withhold of adjudication, modify to include an additional 24 hours of community service work, and include the $100 VOP fee, $150 cost of defense. Judge, I wrote that wrong, and I neglected to put $100 in each case, and a total of $250 cost of defense. I'm going to write that in. Does that change your willingness to enter the plea at all? Okay. In the 25 MM 212 case, Ms. Wiggins would be entering a plea of no contest, waiving her right to go to a jury trial. It would be a time-served sentence, $270 in court cost, and a $50 cost of defense for the misdemeanor with an adjudication. May I approach?
Granted. Those are correct fees and costs, Madam Clerk.
Yes, sir.
And so are the misdemeanor costs going to be paid in the felony case?
Yes, Your Honor. We're going to request that the misdemeanor cost be part of the felony probation.
Okay. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Absolutely, Your
All
Honor.
right, all right. You put your hand down. Now, as part of this is your VOP, but you also have your new misdemeanor case, and we're taking care of them together, but you understand they're two different things.
Yes, sir. Yes,
All
Your
right.
Honor.
You understand as to your VOP is that you're admitting the violations,
Yes, Your Honor.
and that says you agree with what the department says as far as what you violate.
Yes, Your Honor.
And you understand that you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
And as to those, you will be reinstated to complete your original terms and conditions, and you'll have an additional 24 hours of community service plus the additional fees and costs for defense and prosecution of the case.
Yes, Your Honor.
As to the new misdemeanor, you understand you're pleading no contest,
Yes, Your Honor.
and you're sentenced to time served.
Yes, Your Honor.
The court costs assessed there will have to be paid as part of your supervision in the felony case. Do you understand?
Yes, Your Honor.
Okay. Mr. McKinney answered all your questions about the plea and how it affects you,
Absolutely, Your Honor.
and you're satisfied with how he's represented you.
Absolutely, Your Honor.
Court will find the plea to be freely and voluntarily entered into, will accept the plea. Thank you.
Probation on the way out. Mr. Tyler Forrest approaching on a violation of probation, 21 CF 336. Do you have any questions? What?
And Mr. McKinney, there's also 5150 cost of transportation.
5150?
Yes, sir. No, sorry, 5115, 51.15, sorry about that.
Yes, sir. So there's a $51. Judge, Mr. Forrest has an agreement with the state, and the agreement is for an admission to the violation of probation for an 1129 in the Okaloosa County Jail with credit for time served, revoking and terminating his probation. That is a negotiated downward departure. The restitution is outstanding in the case and would be sent to civil lien. There would be the standard costs and cost of defense. And Mr. Forrest did have one question, and I'd like to pose that question to the court. Obviously, with the cost of transportation, he came over from Santa Rosa County. Mr. Forrest has indicated that while he was in Santa Rosa County on an unrelated case, for a violation of probation there, that there was a hold for Okaloosa County for this violation of probation. And his question for the court is whether or not he would be entitled to credit for the time spent in Santa Rosa County while the hold was placed on him for this violation of probation. When that question was posed to me, I told I would ask the court.
And so what date is being requested? I guess that's what I need to know.
It looks like Mr. Forrest, in asking him, stated that he was in the Santa Rosa County Jail on the other case that he was on probation for, which is not before the court today, from about February until June of last year, before his probation was reinstated here on another case. Normally, we deal with cases where he's come straight over here, but I told Mr. Forrest that I would inquire of the court.
Okay.
I was reinstated
Well,
in this case
I
last year, and that's what I know.
The warrant I see here was issued in November of #24.
Correct. So this would have been prior to that, the time in which Mr. Forrest is talking about. And as Mr. Forrest sits and calculates all of his credit for time served, I can see that he is going back and calculating all the time that he has spent in Okaloosa County Jail and Santa Rosa County Jail.
What's the state's position?
I would just defer to, he's legally entitled to any credit. I'm sorry, he's entitled to any credit that he's legally allowed to have. I'm sorry, but this is not my case, Your Honor, so I know very minimal about his time in our position as to what credit he should or shouldn't get.
If the court wishes to announce that he gets just credit for all time legally and he's entitled to, I'll be happy to follow up with the jail.
I guess because I see there were a couple of violations in the past, so.
Correct. So what he's requesting really goes back to prior to the last reinstatement.
Right. And you know, this is calculating credit for time served under exceptional circumstances is really not a simple mathematical calculation sometimes.
Yes, sir.
And this court's approach has been that if there was a legitimate hold on someone and the circumstances are such that it would be inequitable not to give them credit because of the situation, the court believes that credit should be given. I'm not certain, given what I've been presented, that I understand how that would be inequitable. Normally we say where the warrant's outstanding and it's just sitting there and hasn't been served, and so I guess I don't understand. He's legitimately entitled to any time he has any credit he would have in the case.
And this would not be that situation, Judge. This is the court, or would have possibly discretion that Mr. Forrest is asking for that. I don't believe it would be an equity type argument.
All right. So, but we don't really know how much that is.
I've sought a letter of incarceration from Santa Rosa County. I have not received that. But if the court wishes to announce just credit for all time legally entitled to, I'll be happy to follow up with the jail. And if Mr. Forrest seeks any additional time, then we can file that by motion.
Well, okay, we'll do that then, because I'd have to see what those numbers really
Yes, sir.
were to understand and how the overlap with other
Yes, sir.
matters and the other claims to understand that.
And if the Okaloosa County Jail, so Mr. Forrest understands, does not calculate that time, and if he's still seeking that time, I can file a motion for additional
Absolutely.
jail credit.
And when you have all the facts, then I can look at it and say, you know, you're right, it's not fair that he
Yes, sir.
doesn't get that credit, and this is the reason why, but right now, we're speculating, so.
Yes, sir.
I'll say all credit he's legally entitled to, and I'll leave it open for you to look at that, and if you see the circumstances, you can present it to me, and I'll give him a fair opportunity to present those arguments.
Does that mean we have to come back with another court date? That means. May I approach the plea, Your Honor?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You understand that by this plea arrangement, you heard what Mr. McKinney said and you signed the written plea.
Yes, sir.
You understand that you're admitting the violation.
Yes, sir.
And that says that you agree with what the probation says as far as your violation.
Yes, sir.
You understand you're waiving your right to a hearing where the state have to prove that.
I do.
And in this case, you'll be adjudicated guilty. You'll have the additional fees and costs. You'll get credit for all time you're legally entitled to, and you heard that discussion. Mr. McKinney's going to look at that, and he's going to say, present that to me, and if I agree that it's not fair, that you didn't get certain credit, then we'll adjust that.
Yes, sir.
But other than that, it's going to be only the time legally entitled to that's calculated.
Yes, sir.
Okay. And your restitution will go to a civil lien. Your probation is going to be revoked and terminated. You've got some outstanding fees and costs that you're still going to have to pay. Is a year enough time after you're released to get that done?
Yes, sir.
All right. And if you're making payments and you need more time, you can ask for more time to do that.
And Judge, a large chunk of the outstanding cost or cost of supervision with the court
I'll
being
waive the
inclined to
cost of
waive the
supervision based on revoke and terminate at this time. Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Yes, sir. Thank you.
All right, thank you.
Darren Taylor?
This is Mr. Darren Taylor before the court. He is here for a bond hearing in a number of cases. And there is a witness that I have that would like to provide very brief testimony.
Can you call your witness, please?
I would like to call Beth Parsons.
Beth Parsons, please.
This way.
How are you? And raise your right hand, please. Madam Clerk, swear the witness.
Do you swear or affirm that the testimony about to give will be the truth, the whole truth, and nothing but the truth?
And please speak up clearly and distinctly. Direct your voice to the microphone. A recording is being made, so it's important that we're able to hear and understand what you have to say. If there are any objections, stop speaking immediately until you receive an instruction on how to proceed, okay? All right, thank you.
Ma'am, could you please state your name for the record?
Beth Parsons,
How do you know Mr. Taylor?
he's my fiance.
And normally when he's not incarcerated, do you live together?
Yes,
And if you were released, would he be staying at his address?
yes.
What is that address?
910 McFarland Ave.
And that's in Fort Walton Beach?
Yes.
With him incarcerated, are you able to stay at that address?
No,
And do you rely upon Mr. Taylor to help you with your finances?
yes,
Forgive me for asking the question, but currently with him incarcerated, are you currently homeless?
I am.
If the court were to set a bond on the violations of probation in this case and potentially reduce the new law, would you be the person that would be financing the bond?
Yes.
What is your income like?
I'm on Social Security disability.
How much is that monthly?
It's just a little over $1,200.
I have no additional questions for Ms. Parsons.
State has no questions, Your Honor.
All right. Thank you.
Let me step down.
No additional witnesses, Judge, unless you'd like to hear from Mr. Taylor.
It's your case, Mr. McKinney. You
Mr. Taylor?
raise your right hand, please. You swear affirm to testify truthfully in this matter under penalties of perjury.
Yes.
Okay, Mr. McKinney.
Mr. Taylor, have you been incarcerated since January 10th?
Yes, sir.
If the court were to set a bond on the violations of probation, can you make the approximately $211,000 bonds that are currently set?
No, sir.
Is there any monetary bond that you're really going to be able to make at this point that's other than a signature bond?
No, sir.
So primarily, we are asking the court to set a bond in the violations of probation?
Yes.
How close were you to completing your supervision?
4 days.
You were 4 days out?
Yes.
The address that was provided, the 910 McFarland Avenue, is that your address?
Yes.
And that's where you would be staying if you were released?
Yes.
I have no further questions.
Mr. Taylor, are you aware of a pending eviction at that address?
Yes.
Okay. What's the status of that eviction?
It's been extended till April.
I have no further questions, Your Honor.
Okay. Go ahead, Mr. McKinney. Anything?
Judge, we have just argument.
Go ahead.
In 25 CF 100, the court has seen Mr. Taylor at a pretrial detention hearing that it turned into the court setting bond. And then you saw Mr. Taylor at arraignment where we entered a plea of not guilty in 25 CF 100. He's unable to make the bond in that case. We're asking the court to reduce the amount that are currently set. You've heard from Ms. Parsons, who relies upon Mr. Taylor. And at first appearance, but what was not addressed when we had the pretrial detention was that the bonds were set at no bond for all of the violations of probation. I did double check back through all those. It does not appear that he's going to qualify as a violent felony offender of special concern. He is on supervision for a burglary, but it is a third-degree felony, not a second. So I believe that the court, in its discretion, can set a bond in the violations of probation if it chooses to. I would ask the court to keep into consideration very limited resources of Ms. Parsons, who would be financing the bond upon release. If Mr. Taylor makes bond, he would be working with D&D condo cleaning. He would be employed and providing for both him and Ms. Parsons. I would point out in the arrest report or the probable cause narrative, because really the defense only has the probable cause narrative at this point. We do not have discovery from the state or any camera footage that this appears that it is likely going to be a constructive possession case. There are some statements that are alleged in the probable cause narrative that I have not had the opportunity to listen to, so I'm not going to make reference to those. It appears that there were several people in this vehicle that started off with a consensual encounter as the police were effectuating a warrant service for something that was unrelated.
In state?
Your Honor, the state respectfully requests that the bond amount in the 25 CF case remain the same, and that the bonds in the 2019 CF, 21 CF, and the 222 CF cases remains at zero. The main issue for that request, Your Honor, the main reason for that request, Your Honor, is that when we look at the 4 violations of probation, we're essentially looking at 3, possibly 4, instances where this defendant was given an opportunity to go out into the public, to follow the law, to follow the rules of probation, and we see at least 3 separate times, and now we're looking at this alleged new law violation a 4th time, where the defendant has seen those requirements from probation, he knows the law, and continues to either commit a new law violation or to violate probation. Given that he has had 4 separate violations, or 4 separate probation cases, we would respectfully request that the bond remain revoked or at 0 in those violation of probation cases, as he was out on probation when he committed the alleged new law offense. With respect to the alleged new law offense, I believe those facts were argued and articulated when setting a bond. We would state that nothing has changed since that time of that setting of the bond, so we would request that the bond amount in that 25 CF case remain the same, Your Honor.
A rebuttal, Mr. McKinney.
No, Your Honor.
And I guess looking at the, Mr. Taylor says he's 4 days. I'm looking at the report. I think wasn't he on probation till 12/14 of 26? So I guess he was just referring to community control that he was on?
He's likely referring to the community control aspect.
Because I think that's probably, that would have been done on 1/14 of 25. Does that sound right? Okay, okay, yeah. After reviewing all of this and all the circumstances, and then also reviewing the report and then the situation provided, the court declines to modify the bond conditions.
Yes, Your Honor. Your Honor is going to see Mr. Taylor again on March 10th. I would charge the state to try to get me the discovery in this matter ahead of that court date so I can review it with Mr. Taylor, as I know Mr. Taylor wishes to proceed forward to trial as quickly as possible.
All right, very good.
But I just sold them.
Kyle Vincent.
Judge, this is Mr. Kyle Vincent. He is on the docket in 2 case numbers, 24 CF 2189 and 25 CF 265. And these are on the docket as a bond hearing. I did want to point out that I filed this as quickly as I could when it came in, and there is an error in the bond motion. At the jail site shows the bond revoked. The bond is not revoked. In 24 CF 2189, the bond's been surrendered, Mr. Vincent, because of the new charge. And then if we look at these two, it looks like they are from the exact same search warrant. There was additional testing relating to the device in 25 CF 265, which generated a new case, but it is from the same arrest or search warrant, same set of facts. That would mean that Mr. Vincent has a $5,000 cash or professional bond in the 2 primary counts in 24 CF 2189 and a $5,000 cash or professional bond in 25 CF 265. In the 24 CF case, pretrial services was part of that bond, and you are
Right. So be sure I understand that in the 265 case, he was simply surrendered.
correct.
Right?
In the 2189.
I mean, sorry, the 2189, he was surrendered, so he can simply post a new bond in that case.
Correct.
And so we need to, then you're asking for
A reduction.
a reduction.
Yes, Your Honor, because he is currently in jail and he's unable to make the total $15,000 cash professional at this time. The 25 CF 265, the operative set of facts goes to the exact same search warrant, exact same time. There was additional testing on that device.
Shouldn't they be consolidated?
Once the charges are filed, that's my intention to likely file a motion for consolidation. I've had that discussion very briefly with Mr. Snell, but the charges are not filed in 25 CF 265 as of yet.
State?
With respect to this, Your Honor, we would respectfully request that the bond amounts remain the same. Our biggest concern here would be for safety of the public. There's no real way, if you read the report, he's making firearms, making these devices. I can't think of a way where this court can identify particular materials and substances that he's not allowed to be around, and then how we actually go through the hoops of verifying that to make it to where the state could agree to any sort of bond that would ensure the safety of the public. We do feel as though the $5,000 is to each count is a reasonable bond amount for the charges. Just real quick, wanted to look at something. There is a prior, I mean, granted this was back when he was a juvenile, there's a prior aggravated battery with a weapon, Your Honor. Mainly because we don't feel as though there is any other condition of bond that could ensure this court that this defendant isn't going to be engaging in the same type of activity if released on a much lower bond. Then we would request the $5,000 that are in place to remain in place as to each count, Your Honor.
Considering the circumstances in the 2189, and I understand that there really is a single criminal episode based upon the allegations of the two cases. But considering the allegations in 2189 combined with the allegations in 265, the court finds the bond set to be reasonable based upon the allegations made, and the court declines to modify those under the circumstances.
Is the court going to require the pretrial services that was included in 24 CF 2189 to be included in 25 CF
Yes.
265 as well? 'Cause it was-
Concurrent.
Correct, okay. So that keeps it at 15. If you're able to. Madam Clerk, I believe we see Mr. Vincent again on the 13th of March for a arraignment. Is that correct?
The 25 case, yes. The 24 case is on the March 10th cycle.
Okay.
Yeah, put the other case on the March 10th, just so they're running together.
Yeah, sure, thank you.
Okay.
James Ward.
Do you have any questions? Yep. Yep, credit for all time served. This is James Ward before the court in 23 CF 1161. We've reached an agreement with the state for an admission to the violation of probation. Today is the 20th. Do you have any questions? It is. Okay. The agreement that's been reached is for an admission and adjudication of guilt. This was a prior withhold adjudication. The sentence would be 120 days Okaloosa County Jail with credit for all time served. That will revoke and terminate his supervision. There's a $100 VOP fee and a $150 cost of defense. May I approach with that plea agreement?
Yes.
This is a guideline sentence.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand that you're admitting the violation,
Yes, sir.
which says to me you agree with what the department said about what your violation is.
Yes, sir.
Okay, you're saying yes, but your face is going like, I'm not really sure what he just asked me. The real question is, you saw the affidavit of violation and the report of violation. Do you agree that you violated as those reports say?
Yes, sir.
Do you understand by making this admission, you're waiving your right to a hearing where the state would have to prove that?
Yes, sir.
And in this case, you'll be adjudicated guilty to 120 days county jail credit for all time served. Your probation will be revoked and terminated. You'll have the fees and costs were announced. You also have some outstanding fees and costs. How much time after your release do you need to get those paid? Will a year be enough?
It's about $765. Judge, part of that is cost of supervision. Would the court waive the cost of supervision?
I'll waive the cost of supervision based on the revoke and terminate.
Looking at about $1,000, so I'd ask for about a year, 18 months.
About a year, 18 months.
Okay, I'll give you a year and a half. As long as you're making the payment, the goal here is to get you to pay. As long as you're making payments, I'll extend the period of time if you need more time, okay?
Awesome, thank you.
Court will find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication.
Are you on to the total doctor? Huh? Williams?
No, we already did. We already did.
Yeah, I think you're right. Got the pre-trial, 12:30.
But I show a couple people left, right? Do we,
I have a few, yes.
okay, who do you show left, Madam Clerk?
There is Haley Lewis.
Mr. Klein's Haley Lewis.
Yes, Your Honor, we filed a C4 on Ms. Lewis. I don't believe the state filed a traverse.
State intended to reverse the C4.
No, Your Honor, the state cannot in good faith file a traverse or demur.
Motion to dismiss is granted. Who else? Madam Clerk, that's it, except for Neely, right?
I'm sorry, what was that?
Neely, the one we carried over to 1:30?
He's coming back at 1:30,
All
correct,
right.
Judge?
All right.
Madam Clerk, have Tina Williams.
Yes.
Tina Williams,
Is there a
yes.
Tina Williams in the courtroom? Judge, I represent Ms. Williams in 24 CF 1991. I would inform the court that she has a companion case over in Jackson County that she also failed to appear for over there. So there's a pending warrant in Jackson County.
All right. Issue of no bond case.
And then Ricky Wilson.
He's present, Judge, incarcerated. Ricky Wilson. This is Ricky Wilson Sr. before the court in 25 CF 132. He's also on the arraignment docket. There was also a motion for bond filed. We would withdraw that motion because we've reached an agreement.
All right.
The agreement that's been reached is for Mr. Wilson to enter a plea as charged in count 2, which is a misdemeanor. Count 1 will be dismissed by the state. The terms are an adjudication of guilt, 30 days in the Okaloosa County Jail with credit for time served, $270 in court costs, $150 cost of defense. May I approach with the misdemeanor plea?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
Do you understand that you're...
It'll be a plea as charged in count 2.
Just count 2?
Just
No-
count 2.
All right. So you understand you're pleading no contest to the misdemeanor possession of paraphernalia?
Yes, sir.
That you're going to waiving your right to a trial? You're going to do 30 days county jail credit for time served with the fees and costs that were announced.
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with what he's done for you?
Yes, sir.
How much time you need to get the fees and costs paid after you're released?
About 6 months.
Okay, 6 months to pay, and as long as you're paying, if you need more time, just let me know and I'll give you more time.
Yes, sir.
I'll find the plea freely and voluntarily entered into, and I'll accept the plea.
Good luck, Sam.
Now, before we go to the next docket, we'll take a 10-minute comfort break. 10 minutes.
Could you try it?
All rise.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Judge, the Isaac Prado Thomas case ultimately is going to be dismissed, if we can address that.
Sorry. Yes, the state spoke with the victim in Mr. Prado Thomas's case. He came by the office late yesterday afternoon and submitted a job charge request.
Is the defendant here?
Yes.
Well, please bring the defendant out.
Judge, this is Mr. Isaac Prado Thomas in 25 CF 351. Come right here.
Yes, Your Honor. At this time, the state is going to be announcing a no pros of this case. The victim has declined to prosecute and has submitted a job charge request with the state attorney's office that is in our file, and so we would announce a no pros at this time, Your Honor.
25 CF 351 is no price.
You'll be released today. Okay. All right. Thank you. You just follow the deputy. Thank you. Thank you, Judge.
afternoon, sir. I'm Gene Mitchell.
Good afternoon.
I'm here with Mr. Simmons.
All right, we ready to proceed?
Yes.
Stage ready, yes, sir.
All right. You may have a seat at the council table.
If the government had more than one witness, would you please sequester them?
All right, who all does the state intend to call as witnesses in this matter?
Judge, I have Ms. Margie James, Anthony Crage.
Well, have them step in down in front of the rail, please. All right, come on in, so get them up here in front, we'll get them all sworn in, have them state their name. All right, just stretch out here and face this direction, all right? All right, each of you raise your right hand, please. Madam Clerk, swear the witnesses.
Yes, sir. Do you swear or affirm that the testimony about is going to be the truth, the whole truth, and nothing but the truth?
All right, and you each state your name, starting right here. And in the back there?
Margie James.
Anthony Crage.
All right. You've each been called, told that you've been called as a witness in this case. The court has invoked a rule that requires you to remain outside of the courtroom at all times except when you're called to testify in the matter. You may not discuss your testimony among yourselves or either before or after your testimony. You may, however, discuss your testimony one witness at a time with any of the lawyers in this case. If you violate this rule, it may subject you to sanctions such as contempt or having your testimony disqualified from being heard by the court. So at this time, if you'd please remain outside until you're called to testify in this matter. Who's your first witness?
I would like to call Ms. Margie James, Your Honor.
All right. Helping you get a few extra steps today. Come on. And if you please have a seat right there and direct your voice to the microphone you see there in front of you. Speak clearly and distinctly. It's important we're able to hear and understand what you have to say, okay? If there are any objections, stop speaking immediately until you receive an instruction on how to proceed, all right? Mr. Snell, you may inquire.
Yes. Ms. James, I know you just did this, but for the record, would we please state your full name?
Margie James.
Okay, Ms. James, this past weekend on Saturday, I guess it was February the 15th, were you in Fort Walton Beach?
Yes, sir. I was driving on Bill Parkway going toward Niceville.
Okay. Now, when you were driving, did you observe anything out of the ordinary?
Yes, sir. Very, very loud flashbang type sound.
Okay. What did the flashbang catch your attention, your eyes? What did you see?
Yeah, immediately. You just saw a flash of light and smoke went up. It was near the Jimmy John's drive-through area. Yeah. And as soon as that shockwave hit the car, the dash cam video immediately goes on because it feels the shock to the car. And so it began recording.
Okay. What did you think happened?
I thought somebody was bombing Fort Walton Beach. It was really loud. But, you know.
May I approach, Your Honor?
Granted.
Tell me if you know what that is.
Yes, sir. It's a video of the dash cam that happened that day. Signed and dated it.
Is it your dash cam?
It is absolutely, yes, sir.
How do you know that?
Well, I've signed and dated it. I viewed it right previously before coming in here.
Your Honor, I'd like to move this into evidence as it states
Stipulated.
All right, it's admitted.
Okay, and I would ask to publish it record.
You may publish. Let me know when you're ready.
Okay.
You need her password.
Right, password. Didn't anticipate that, I'm sorry. My computer requires password. Didn't have the volume on, Your Honor, I'm sorry. I can play that one more time. Did you hear that sound, like the little bell?
Yeah, that's the, like I said, that's the point. The dash cam felt the car shake. And so when it felt that, it immediately starts recording 30 minutes behind you and in front of you from there on out.
Okay. So you said if the car
Did I say
shook,
30 minutes? I meant 30 seconds.
you said the car shook when you felt like shock waves, if you will?
Yeah.
So this is not going to be accurate or perfect, but how I can't tell how far you are away from where that explosion. Do you have any idea how far you would think that was?
I imagine it was less than 100 yards, I would think.
Okay.
Because we were seeing it as it was happening on the left.
Okay.
So it caught your eye because the flash and then the smoke, but the car shook, so you knew exactly something had happened.
Okay. All right. I don't have any further questions, Your Honor.
Mr. Mitchell,
None. Thank you, ma'am.
is the witness released?
Yes.
All right, thank you very much. You're released at this time. You can remain in the courtroom, and you're released from your obligation not to speak about your testimony except with the other witnesses, or you're free to go. You finished making your presentation?
Yes, sir.
Good afternoon once again. Please be seated. You see the microphone there in front of you. Direct your voice to the microphone. Speak clearly and distinctly. It's important we are able to hear what you have to say. There's also a court reporter in the back of the courtroom taking everything down, okay?
Yes, sir.
If the lawyers make an objection, stop speaking immediately until you receive an instruction on how to proceed. Is that okay?
Yes, sir.
You may inquire, Mr. Snell.
Great. Sir, will you tell the court for the record who you are, what your name is?
My name is Anthony Crage.
So what is your occupation, Mr. Crage?
Delivery driver / store employee for Jimmy John's restaurant.
Okay, that's the Jimmy John's store in Fort Walton Beach?
Yes, sir, on Bill Parkway.
Were you working this past Saturday on the 15th?
Yes, sir, I was in the drive-through box taking care of a customer at the window.
Okay, so that was what your duties were that day, was working the drive-through?
Drive-through, I take orders through the drive-through or on the front counter. Basically a roundabout position,
Okay.
all around do.
Okay. So I guess there was some type of disturbance that happened, some type of explosion or whatever happened on Saturday. Were you there at that time?
Yes, sir. I was in the delivery box, or not the delivery, but the drive-through box, as what we call it, because it's like a little box.
Okay. Will you talk us through like what happened when this event happened? Describe what you saw and what you witnessed.
I was talking with the customer. Basically, he was right here with his vehicle. I was talking with him, getting ready to take his money for his order. And then all of a sudden, I hear this explosion. It sounded like a muffler going off. I look around and I feel glass on me. I'm like, I'm like, what just happened? And I see a puff of smoke. I was like, did somebody's muffler blow? What happened? I go outside and I look and there's just a ball of smoke. Just.
When you said you went outside, so you were inside the store?
Yes.
When it happened?
Yes.
And then you walked outside to the store?
Yes, we have a side door that.
Okay. And what did you observe when you walked outside?
Glass busted. The light fixtures for the outside have been knocked out. And the glass that was behind me was all shattered. I mean, I got sprayed with it.
Tell me, were there any other damages to the exterior of the building there?
There was a few scrapes on the building that I could see.
Holes in glass, anything like that? Glass shattering out or anything?
There was glass shattered out, yes.
Okay.
I mean, we had a couple of our windows, like the one window that faces the road from our box has a window pane right there, and if it wasn't for safety glass, I would have been cut up even more.
Now, the origin of that, did you see anything, any
I did not see
people
anything.
or cars drive by?
No, I did not, sir.
Okay. So you weren't actually looking out the window when it happened?
No, I was actually facing the register.
Okay.
Which, where it happened would have been like in this vicinity, and I was facing this direction.
Okay. If you had to describe the force of the boom or the blast, how do you have any adjectives? How would you describe it?
Shocking. Because not expecting anything like that, especially in our little area.
Could you feel it?
I felt a little bit, but it was mainly of the glass.
Okay. Okay.
Is what I felt the most of,
So
was
it's
the glass.
More of a sound for you than anything. Okay. All right. I don't have any further questions, Your Honor.
Mr. Mitchell,
None, Judge. Thank you, sir.
hold on, just any is the witness released?
Yes, sir.
All right. Now, you're released from your obligation not to speak about the case, and you can remain in the courtroom if you wish to see the outcome. You just can't talk to other witnesses yet. It's your desire. You can leave if you wish. Yes, sir.
Thank you, sir.
Thank you.
Your Honor, this witness will need to be sworn. She was not brought up at the time.
All right. If you'd remain standing and raise your right hand, please. Madam Clerk, will you swear the witness?
Yes, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Please be seated. And if you would, direct your voice to the microphone you see in front of you. Speak clearly and distinctly so we can all hear and understand you. Also, there's a court reporter in the back of the courthouse taking everything down, so it's important they're able to make a good record of what you say, okay?
Okay.
If any of the lawyers object, stop speaking immediately until you receive an instruction on how to proceed. Is that all right?
Yes, sir.
Okay.
Would you
You
please?
may inquire, Ms. Herndon.
Thank you, Your Honor. Would you please state your name for the record?
Patricia Roby.
And where are you currently employed, Ms. Roby?
Harley Davidson, Emerald Coast Harley Davidson.
Were you working at the Harley Davidson on February 15th of this year?
Yes.
Was there an incident that occurred at work that was unusual for you?
Yes.
If you could just tell the court kind of how things started, what your responsibilities were that afternoon and what happened.
We had just finished a chili cook-off at the dealership, and I was cleaning up. I had grabbed some bags of trash, and I came out the side door to bring them to the dumpster.
Okay. And when you walked out to the dumpster, what happened?
When I got out there, I heard screaming. Do you want me to tell you what I heard?
Yes, you can say what you
Okay.
heard.
I heard, take that off. Someone was yelling, take that off. And I assumed that they were kicking a brother out of the club. So I just kind of faced forward and took the bags to the dumpster. And then when I came back, it's when I noticed that it was more than just what I thought it was originally.
Okay. Let me take you back for just a second. You said you had overheard screaming, somebody saying, take that back, and you thought they were kicking a brother out of the club.
Mhm.
Can you tell the court what you mean by that? Who was there on that particular date at the dealership?
We had a lot of people there, but there were clubs there. They wear their vests to let you know who they're with.
And were you able to identify any of the vests that you saw? What were those groups?
It was the pagans and the outlaws.
Okay. And I believe that you previously said that when you heard that statement said, you thought that they were kicking a brother out, but it ended up being something worse. Can you tell us what you saw and what you heard?
Yeah, so when I came back to closer to where they were, he was yelling, "I'm not done with you, I'll be back, you need to take that off."
And I'm going to stop you for a second because obviously we weren't there, so we have to recreate the event. You say you heard a man yelling this.
Mm-hmm.
Where was that man? Was he in a vehicle? Was he standing outside?
He was standing outside of his car.
Okay. And what happened after he yelled, we're not done, take that back?
He was just being very threatening, and then he kind of got in his car and he started to pull out of the parking lot. And then at that point, I had went into the building and went up to the sales tower where the managers are to let them know that there was a situation out in the parking lot. And at that point, I had heard women on the phone with 911, and I had looked out the window, and that's when I saw like the flash and heard the bang. And I told everybody to get down.
Ms. Roby, could you describe the vehicle that you saw that man get into?
It was a 4-door silver Subaru.
And were you able to see this man that got into the driver's seat?
Yes.
I want you to look around the courtroom and tell me if you recognize that man in here today.
Yes.
And if you could point, I'm not going to ask you to point out him, but if you could just describe generally where he is seated and an article of his clothing.
He's on the right side with the orange outfit on.
Now, you said after he made these comments and said, "We're not done here," you went inside and things are going on there. During that time, did something get your attention again?
Yeah, I heard the bang.
Okay. Could you tell where that was coming from?
It was coming, well, I looked out the front building and it was over in the Jimmy John's parking lot.
Okay. What did you see, just kind of generally?
It was just, all I saw was a flash, and that was pretty much it. I turned around and got down.
Okay. When you identified this man that made the statement about, "Take it back, we're not done here," who was he directing that at? And I don't need a name, but just generally, was there a group of individuals?
Yeah, it was the Pagans, and one of them had just bought a new bike, and he was transferring stuff from the old bike to the new bike.
And after you heard the bang and saw the flash of light, were you able to see where that silver Subaru went?
No.
Did you ever see it in the parking lot after that point?
No.
One second, Your Honor. Your Honor, those are my questions for her.
Mr. Mitchell.
Good afternoon. I'd like to talk with you about a couple of the answers that you just gave, okay?
Yes, sir.
And the reason is, I feel like I heard you give an answer, and then I heard the Assistant State Attorney restate, and I wondered if there's some accuracy there or differences, right? In fact, did you see folks that you would characterize as outlaws, or did you see someone you would characterize as outlaw?
One.
Okay. In fact, did you hear a person say, "I'm not done with you," or did you hear a person say, "We're not done"?
It was I.
One of the first things that you said was along the lines of, "Well, I heard something and I assumed that a brother was getting kicked out of a club." Is that what I heard?
Yes, I heard the yelling.
All right. And you've worked at this Harley dealership for how long?
Since October.
All right. Is this dealership frequented by this group that calls themselves Pagans?
Every once in a while, yeah, they all come.
Okay. On this day, is it accurate that any of the folks that would be in a particular club, with evidently the exception of one, was a member of the Pagans, or were there other clubs there that day? If you know.
I remember the Pagans just because they were in my office and I was working with them directly. As far as the other vests, I mean, there's multiple clubs and I'm not familiar with all of them.
Okay, I don't want to put words in your mouth, but are you telling me that on this day there were various clubs or just one primarily?
No, there's various.
Okay, all right. You told the judge that you saw one, and then you suggested quite sternly that the one that you saw is here in the courtroom today and indeed was sitting with me over at this table. How far away were you from the person that you've identified?
probably 30 feet. 30
Okay,
to-
and give us the dynamic, like where were you and where was that person, what have you?
I came out the side door and they were standing,
Forgive me, who's they?
the Pagans.
Okay.
They were up with the new bike, transferring his stuff.
About how far away?
They were probably 10 feet from the door.
Yes, ma'am?
And then he pulled up at the, kind of cornering them in at the alley. So he was probably, I mean, he was 2 car lengths maybe away from them.
Okay, so help me, because we were not there. How was one person cornering them in?
So they were, there's like a curb.
Yes, ma'am?
So in between the building and the curb is an alley. And so they were in between the curb and the building, and he had come up on this side of them, between the curb and the building. And he had pulled his car in right there, pointing towards them.
Okay. Do you have a feel for how tall the men were that were not the gentleman you identified today?
Who? I'm sorry.
You said he cornered them in. I'm interested in knowing how tall they were.
Maybe 5'6" to 5'8".
Okay. And the gentleman that you saw cornering them in, how tall was he, if you know?
That's the same guy.
Okay. Very good. What I intended to ask you was the folks who were cornered in, how tall were they?
Oh, they are, I don't know, 6 foot.
Okay. So you see my question. How is it that the person that perhaps 5'6", 5'8", by himself, is cornering them in when they are roughly 6 feet? The point is larger people.
They were standing in a group in between a curb and a building, and the individual in the car pulled up to them. And, I mean, there's really nowhere for them to go.
Okay. Well, I don't want to put any words in your mouth. I appreciate your answers. 10 seconds, please, Judge.
Yes, sir.
Ma'am, I want to ask you one more question about what it is that you've told us that you heard. Okay? Scale of 1 to 10, 10 being very good, 1 being not so good. How confident are you that you heard what you told us you heard?
100%.
Okay. The follow-up from that would be, there have certainly been times in your life where you were quite confident about something only to find out you're inaccurate. Fair?
That's fair.
Okay. Judge, those are my questions.
All right.
I don't have anything further. She may be released.
All right. You're free to step down now. You can remain in the courtroom if you want to see the rest of the proceedings. You may not talk to any of the other witnesses about their testimony, however, or yours. Thank you. Yeah, would you spell your last name?
R-O-B-E-Y.
R-O-B-E-Y? R-O-B-E-Y. Good afternoon. Please be seated. You were previously sworn. Please direct your voice to the microphone in front of you and speak clearly and distinctly. And if there are any objections, stop speaking until you receive an instruction on how to proceed. All right?
Yes, sir.
All right. Mr. Snell.
Yes, ma'am, could you please state your name for the record?
Yes, Deputy Sheriff Bianca Warnick.
Would you spell your last name for us, please?
Warnick.
Thank you.
Where is it that you're employed?
Okaloosa County Sheriff Office.
How long have you been employed with the Okaloosa County Sheriff's Department?
Approximately 2 years.
2 years, okay. Were you on duty on Saturday the 15th?
Yes.
What were your, where were you patrolling? What were your duties that day?
I was patrolling, I was a rover, so I was like everywhere. I saw the call and I just
So when you say I was roving what?
Rover, we have to cover all the zones, so every area for Walton Beach.
Okay.
Yeah.
Now, there was an incident that occurred at the Jimmy John's or the I guess, and the Harley-Davidson motorcycle shop. Were you called out to that?
That's correct. I saw the call popping at the dispatch, and I put myself en route.
When you arrived to the scene, can you just explain what happened when you arrived?
Yes. When I arrived, a Harley-Davidson employee approached me saying, hey, a suspect drove by with a silver Focus.
I'm lodging a hearsay objection. I recognize it's admissible in a hearing like this, but I should lodge the objection in.
Your objection is noted and overruled.
The employee arrived, told me that he saw and also the motorcyclists that were gathered at the parking lot have videos of the suspect description and the suspect's vehicle, and that is a bald guy, white, wearing an outlaw jacket. And he pointed a gun at them and detonated a flashbang. He then proceeds to walk me through the motorcyclist gang members. They were called the Pagans. I interviewed one of them. He showed me a video of the suspect and also the vehicle description. I provided that to my trainer, Deputy Lepee. He put that on the call, on the radio, and that's mostly what I did at that point.
So when you spoke with an employee, I guess, at the motorcycle shop, they pointed you to a group of people.
Yeah, that's correct.
How many people would you say was in that group?
Around 8.
Around 8?
Yes.
And then you walked over and just started talking to them?
Yeah, one of them mostly got out of the group and talked to me and showed me, like, look, watch this video. This is what happened. I saw the video. We got a screenshot of the tag, and that's when I asked my trainer to put it out so deputies can go get the vehicle.
So the person that you spoke to was, what you're saying was actually one of the group that had
Yes.
the gun pointed at them?
That's correct.
Okay. What specifically did he say about that?
He said, this dude, he's white, has a beard, he's wearing an outlaw jacket. He just pointed a gun at me and my gang and took off, turned, and dropped a bomb at Jimmy John's. And I'm like, all right. And we pointed
Did he
him.
describe the firearm in any details at all?
He said rifle.
Rifle?
Yeah.
Did you have the opportunity to go over to Jimmy John's and inspect that area as well?
Yes, once I was done talking to that member of the motorcycle club, I went to Jimmy John's and I assisted other deputies to protect the scene. I took pictures of the damages and what it appeared to be part of the detonation, which is like a lot of cardboard pieces spread it out in the parking lot. So I took pictures of that as well.
Describe what kind of damage that you saw to the building of Jimmy John's, the restaurant.
There was a lot of damages on the windows, broken windows, a couple of those. The wall was kind of torn in the side. The ceiling also where the light covers was down, and you can see the mark of where the detonation was, like a very visible mark.
So did you talk to any employees that witnessed the event?
I did not.
Okay. So in your estimation, there were at least 8 eyewitnesses that were there that saw this?
That's correct.
Okay. Now, once you received the information, you gave that information to another deputy that put it out so that it was broadcast to all law enforcement on the road to look for this vehicle that matched the description?
That's correct. My trainer, Deputy Lepee.
Now, what was the description of the car? Right? What specific details did you put out there?
In the beginning, the employer of Harley Davidson said a Ford, and when we looked at the picture and the videos, it was corrected Subaru, and it could be mistaken because of the background. It was blue, like a Ford. So we corrected that and provided that, and also the Florida tag 36 Delta Foxtrot Whiskey Charlie, which is from the suspect.
Eventually, that car matching that description was pulled over, is that correct?
I believe so, yeah. Yes, sir.
Do you have any knowledge of how long after you broadcast the updated details that the traffic stop was conducted?
I cannot recall. I can say for a fact that it was quick.
Okay.
Yeah.
I don't have any further questions. Thank you.
Yes, sir.
And would you please remind me your title?
Deputy Sheriff.
Deputy, it's fair, is it not, that everything that you're here to tell us today is something someone else told you?
No.
No? Okay. Would you tell us who it is that gave you the account?
The account?
Yes, that you just relayed to us. You told us that you were told by one of the people there. Can you tell us who it is that told you that?
I do not recall his name.
Okay, all right. Judge, those are my questions.
Redirect, Mr. Snell.
No, sir.
Is the witness released?
Yes, sir.
Thank you very much, Deputy. You're released. How you doing, sir? Good. Welcome. Please be seated. Thank you, sir. I'm going to direct your voice to the microphone you see in front of you there. Speak clearly and distinctly so we can hear and understand you. And if there are any objections, please stop speaking until I give you an instruction on how to proceed, all right?
Yes, sir.
Mr. Snell, you may inquire.
Will you please, for the record, state your name, please?
Anthony Michael Costantini, Jr.,
And where are you employed, sir?
Okaloosa County Sheriff's Office.
And how long have you been working there?
I believe it's 10, 12 years.
10 or 12 years?
Yeah.
Okay. So this past weekend was the 15th Saturday. Were you on duty that day?
Yes, sir.
What were your duties that day?
K-9.
K-9?
Yes, sir.
Okay. Any specific zones you were patrolling?
No, sir. Central.
Central.
Yes, sir.
There was a call out, there was an incident that took place at Harley Davidson and the Jimmy John's. Were you called out to that?
No, sir. I just showed up. I wasn't called to it.
How did you become aware that that?
I heard it over the radio.
Okay. When you arrived, was it pretty soon after it occurred, or you? At some later point?
We still hadn't got a good description of the vehicle. Other deputies were talking to people on scene when I got there.
When you, what did the scene look like when you got there? How many people were out there that were not law enforcement?
There was a lot of people.
A lot of people?
Yes, sir.
Okay, what was happening?
There were some people over at Jimmy John's in front of the broke window. There were some people over at Harley Davidson. There was deputy talking to the people at the sub shop, and then there was deputies talking to people at Harley Davidson.
Did you begin to start doing a task or an investigation at the time you got there?
My main concern was if the individual was still on scene or close by, direction of travel, and we still hadn't had a clear vehicle description. That's what I was trying to get.
Okay. And then at some point, how did you get the vehicle description?
Somebody said, and I'm not sure who it was, but said that he may have went over behind Aldi when he left the suspect. So Deputy Rubo was on scene, and I know he's SRT. So knowing that he was supposed to be armed with a long gun, I wanted to take the best person available with me. So I got him, and we went over behind Aldi and started looking.
And you wanted to take someone with that capability because why?
He's trained for that type of work.
You felt the need to have him along because what was the need?
If it comes to shooting,
Okay.
I want the best shot with me.
So,
I have a dog. That's my best thing. He's a sniper, or he's going through sniper school. He's SRT member. I want to have the best with me if we get into that type of situation.
so the details of the incident that you heard made you think there could be
Yes, sir.
violence?
Yes, sir.
Okay. So then you heard the description, you went to Aldi or went around that area, and then what happened?
When we got to the backside of Aldi, back towards Herbert Road, my canine partner, Luke Mitchell, Luke, he called over the radio, said he had the vehicle over off Lewis Turner. The vehicle description came out, and then right after, Luke said he had the vehicle on Lewis Turner. So myself and the other deputies went that way.
Okay. And then describe what happened when you went that way.
We had to catch up with Luke and the suspect vehicle. We caught him at 189 and 85. We went around traffic. Luke was talking over the radio about conducting a felony traffic stop once we made the turn. Once we got clear, everybody got clear of traffic, and we got up with Luke. Luke initiated the traffic stop.
Okay. And so Luke is the lead car that pulls him over?
Yes.
And then where's your cruiser?
I'm right behind Luke.
Right behind him?
Yes, sir.
Okay. And then describe what happened then.
I pulled up, Luke pulled up at an angle to the left. I pulled up behind the vehicle and crossed my vehicle up, so I had protection with my motor. The description was that he was supposed to have a long gun, so I wanted as much protection as possible, so I was using my motor to cover myself. Luke was giving commands. We got him out of the vehicle. He came back to us. I think Rubo and his trainee put handcuffs on the suspect and searched him, patted him down.
Okay. What was there any result of pat down?
I think he had a knife on him, a pocket knife, a regular pocket knife.
Okay.
I mean, that's about the only thing I remember him really having that meant anything to me.
Now, the car, did you search the vehicle?
We did what we normally do on a felony traffic stop. We went up and cleared it from the driver's side.
What does that mean, cleared?
Make sure there was nobody else in the vehicle.
Okay.
So we went up the driver's side. I believe I was last in line because I ended up taking the trunk. I held the trunk until they cleared the front. Once the front was cleared, they popped the trunk and we cleared the trunk. We didn't find anybody else inside.
Anything else located in the car that's of note?
Not at that time.
Okay.
I can't speak for the other two deputies. I know I didn't see anything at that time.
Okay. Did you see anything at any other time?
Yes, sir. I did go up and do a outside check of the vehicle on the passenger side. After we had the individual secured, I went up the passenger side, and that's when I saw the gun protruding from, I think it was a jacket, and it was the butt of the gun was sticking up, and what I thought was an unexploded device.
Okay. When you see that, it was what you would call in plain view? Is that
Yes,
how
sir.
you would characterize that?
Yes, sir.
What did you do with that information?
I forwarded over the supervision over at the main scene.
Okay, and what did they do with that information?
They coordinated what they needed to coordinate.
And then,
Bomb squads and ATF came out later on.
okay. When you say later on, how long are we talking about?
It takes them a while to get here.
Okay, so
I don't know exactly where
When
they
you
came
s-
from. They came from Panama City and Pensacola is what I believe.
when you spotted that and you put it out there, at that point, you don't touch the car because,
No, sir,
and the reason you don't do that is why?
because we don't know what kind of explosive device that is.
Okay. Now, eventually, ATF comes and does their investigation. Was anything ultimately found in the vehicle?
Something was found, but I don't know exactly what it was. You'd have to talk to the bomb guys. I know that they were talking that something was found, but at that point, I was shifted to traffic control,
Okay.
myself and Luke.
So the firearm in the car and the explosive device, you didn't see it any other time other than for what you saw in plain view?
Yes, sir.
Now, the call out, the original call out to Jimmy John's and Harley Davidson, where's that located?
The actual call,
Yeah, where did you respond to? Is that Beale Parkway?
Bill Parkway.
That's
Yes,
in
sir.
That was in Fort Walton?
Yes, sir.
Was that in Okaloosa County as well?
Yes, sir.
Okay. When you you guys did the felony traffic stop and you had the suspect removed from the car, do you see that person in the courtroom today?
Yes, sir.
Okay. Can you describe him for me?
He's wearing an orange jumpsuit, beard, bald head.
Okay, and that's the same person?
Yes, sir.
Okay. I don't have any further questions this time, Your Honor.
Mr. Mitchell.
Sir, the traffic stop was how far away from Jimmy John's?
I can't give you a exact distance. I mean, it's 85 and 189. We turned going back towards the airport on 85.
Okay, I'm not trying to pin you down. Under 10 miles?
I have no idea.
Okay. Would it be your testimony that Mr. Simmons was cooperative?
Oh, yes, sir. Very cooperative.
All right, Judge, those are my questions.
Very.
Redirect.
No redirect, Your Honor.
Witness released.
Yes, sir.
All right, thank you very much, Deputy. You're released.
Yes.
Good afternoon again. Please be seated.
Thank you, sir.
Direct your voice to the microphone in front of you. Speak clearly and distinctly, and if there are any objections, stop speaking until you receive an instruction on how to proceed, all right?
Yes, sir.
Mr. Snell, you may inquire.
Thank you, Judge. Ma'am, could you please state your full name for the record?
My name is Courtney Saunders.
And what is your occupation, ma'am?
I'm an investigator for the State Attorney's Office.
And in your duties as an investigator, do you often listen to and view jail calls?
Yes.
Okay. And like how often do you do that?
Probably almost every week.
Okay. So how do you have access to the jail calls?
I have a login special permission.
From?
The home wave.
Okay. And is that associated with Department of Corrections?
Correct.
Okay. When you view and listen to these jail calls, You analyze them for content and accuracy of the content and reliability as far as that they are actually what was on the calls at the time at the jail?
Correct.
Okay. Now, how does that come about that you would need to listen to jail calls? What initiates that?
We have kind of like an IR ticket system with our program where
IR.
either a secretary or a state attorney would want you to listen to something, and it goes through the ticket system, comes down to me, I look at it, read the case, log in, listen to the jail calls, and then I report back what I find.
Okay, so when you log in, the login from Department of Corrections, there's information there.
Yes.
And then you collect it, is that right?
Yes.
Okay. And then you store it in some capacity, whether it's on your hard drive or?
I do have the abilities to download, yes. I can download and I can put them into separate files and I can put them on my computer, or I can just leave them there and listen to them whenever I want.
Okay, now, do you have the ability to alter them in any way?
No, I do not.
Okay. In this particular case here, this is State versus Simons. Did you do that in this case?
I did listen to jail calls for this case.
Okay. Now, Your Honor, may I approach the witness?
Granted.
Do you know what this is?
I do.
What is it?
This is a disc of this particular case that has the jail calls on it that I listened to, and my signature is on it.
And you've looked at that and listened to it?
I have.
So this was taken from your login?
Correct.
From your computer and transferred to this disk?
Correct.
And it wasn't altered in any way?
No, not at all.
So what's on this disk is?
What is on the home wave?
Okay. And what's on the home wave is effectively the jail call, correct?
Correct.
Okay.
Yes. I have not shortened it or done any editing to it whatsoever. I do not have the capabilities to edit content. I can only edit time frames.
I would like to admit this into evidence, Your Honor.
Mr. Mitchell.
Stipulated.
It's admitted.
Okay. And I'd like to publish it as well, if I could. Or I would.
Permission to publish is granted.
Thank you, sir.
Let the court know when you're prepared.
Okay, thank you.
You ready for me to connect you?
Yes, sir.
Messed up. It busted the windows out of the drive-through and one of the other side windows, and a piece of grass. Yes, it really did. They put it on the news. It's all over the news.
That's what I heard.
All over the news, all over Facebook.
That's what I heard.
And crazy girl is running her mouth.
About what?
Stuff.
Okay, well look, it's my new desk that I got.
Yes.
Get it out of there. Get everything out of my house.
Well, the trash has already been taken out, and I think Greg's gonna come stay with us for a few days because he doesn't want to be there when that happens. That's the next question. What do you? Yep, they're calling in what?
Go ahead, I'll share them with them.
The Jimmy Johnson bomber.
Got it. Even though it wasn't for Jimmy Johnson, it was out in the middle of the parking lot. But, tell Tiny, the girl that you're talking about, tell me to handle that.
Okay.
But call Tiny when you get off here for me and get Dan's phone number, anybody else's phone number, whatever, alright?
Okay. Can I call Tiny at any time?
Yeah, call him right now. I don't have his number though, but.
No, I have it.
Yeah, okay.
Okay,
Alright, thank you.
yes, love you. Love you.
Love you. Bye.
That phone call that you heard there, was that, how do we know that that's Mr. Simons talking?
It has his, when you're looking at it on the home wave, it has his ID number. It tells you what tablet he's either calling from or what phone he's calling from, where he's calling from inside the building. And it has his name and all his identifiers. And then it also has the ID picture image of the person he has been talking to. So you can verify who he's talking to as well, because they have to submit an image of their identification in order to be verified to use HomeWave.
Well, hi.
Hey. What are you doing?
I'm walking around outside.
That must be nice.
It is. It's a nice sunny day.
Yeah.
There's no smoke billowing in the air.
Oh, that sucks.
How is it in there? Dull and gray?
Yeah.
Are they feeding you ribeyes and corn on the cob and mashed potatoes?
No, I don't even know what it is. It's horrible.
Oh. Yeah, unfortunately, I don't think they're going to give you bond.
Why? Is that what the attorney said?
You have 3 felonies and 1 misdemeanor. The explosive one is the one that the feds are involved in.
Right.
And because it busted out the glass of a business, and even though that they claim it was a minor scratch, you caused bodily harm to someone.
Right. But I didn't mean, I get that.
I know you didn't mean to, but it looks, the lumps are just as bad as those others.
Yeah.
And I know that wasn't, or I assume that wasn't the target. But unfortunately, your aim was terrible.
Well, it's in the middle of the parking lot at Harley. It's the same, they're in the same parking lot.
It's not really in the middle though. Where it goes off is like where you pull out of the Jimmy John's drive-through driveway.
Well,
So I don't know if it,
yeah.
I don't know if it, the wind blew it over that way or what, but
and then knocked like a softball size hole into the side glass.
Damn, I should have done that at Harvey. So stay at the house.
I think he's afraid they're gonna come kick the doors in.
Okay, then that's. Remember when I told you to get out of there?
Yes,
Okay, well that's like now.
right?
That way y'all can get money and all of that. And if you have to take that stuff somewhere, take it to the strip club.
Right,
That most of that stuff is rooms.
okay.
So if you need to call them, or if you need to go out there and talk to them, if you need to just go to the strip club and say, hey, y'all need to come to my brother's house right now and get your stuff out of here.
Right, but isn't that tampering evidence?
It's not my property.
Ah, gotcha. Okay,
It's
then,
their
yeah,
property.
then I will tell them to come get their property, because you're gonna be a while.
It's the desk. No, don't tell them I'm gonna be a while. We're gonna
He's gonna be out shortly, but he wants you to come get your
Look
stuff.
at that. Tell them to get their shit out of my fucking house.
Okay, I'll let them know that.
The whole desk.
The whole thing, I'll tell them to get it all.
Yeah.
Whatever all that is, you just go get it. You know what it is, you go get it.
No, they don't. You're gonna have to go there with them and show them the desk because they haven't been to my house.
Oh, gotcha.
Gregor knows too. Just go, do what I'm telling you. Leave your house right here when you get done talking to me and go to the strip club and tell them they need to come with you to get the stuff or whatever.
Okay.
It's important. And then, that's all that I know of. You can take and get my firearms out of there. Get rid of them if you need to get rid of them or whatever. They're all in my closet on the right-hand side.
Are they yours? Is it something Dad
Yeah,
gave?
mine. Dad gave me some of them.
Okay, so they're registered to you?
Everything's, I don't know if they're all registered to me, but they're all legal.
Okay.
Everything I have is legal, but apparently to the fireworks.
Right, no, they're not. They're not.
The Constitution says it is, but okay.
Well, then I'll get the guns that Dad gave you.
It's all of them, everything in the closet.
Okay.
They're all on the right-hand side. But you can tear the closet apart if you need to.
Okay. So where's your fun?
They have it.
Gotcha.
I didn't give them the code to it though, even though I don't know if they can, I'm sure they can, but they tried to give me the code and I said, nah. Well, there ain't nothing on there. Not.
Ms. Saunders, this video call here, did that have the identification markers that you talked about that identified this as being a call from the defendant?
It did.
Wow, bro. You funny, man. You crazy dog.
I can't help it. Vegas was there. He killed my brother.
Funny man. You crazy dog.
I can't help but take it from there. You still want to?
Don't say too much. Don't say too much.
I think it was a city.
Yeah.
Same question. That jail call was identified a call from defendant Gregory Simons. It had the same markers and the same numbers and
It did,
accounts.
yes.
Your Honor, I don't have any further questions for Ms. Saunders.
Mr. Mitchell.
Afternoon, Ms. Saunders.
Good afternoon.
I'd just like to explore some of your answers just a little bit. You're employed at the state attorney's office?
I am.
You have an office there?
I do.
Okay. If we were to try to get jail phone calls, it might be a process where we might ask your office, we might then make a public records request of 2 different agencies, and it takes a period of time.
It does not come through us.
Yes, ma'am, I understand that. What I'm interested in is delineating what's involved if you were to do it. If there is a telephone call you were interested in 5 minutes ago, would you be able to get it?
Yes,
Okay. If there's a telephone call 5 months ago, would you be able to get it?
depends,
Okay. 4 months, 3 months?
depends.
Okay, and help me understand, depends upon what?
So the jail just switched systems. They went from Securus to HomeWave. So I don't know how far back I can access calls right now. We're still learning how far we can go back with it.
Okay.
But if I need a historical phone call, I call the jail, and the jail gives me what I need. If I can't access it on HomeWave, because they keep the records at the jail.
Very good. Now, if before we switched over to HomeWave, or by we, forgive me, not we, before the jail switched over to HomeWave, then how easy was it for you to get jail telephone calls?
The same. I have a login,
Okay, and so how long have you been an employee of the state attorney's office?
3 years.
Right? And so a year ago, last summer, for instance, how easy would it be for you to get jail telephone calls?
I would put in a request via email to the jail and say, this is the time frame, this is the person that was in jail at that time, I need the jail calls from this time frame. They will call me when it's ready, I go up there and pick it up.
At no time have you had to reach out to the Board of County Commissioners or the like to make a public records request? You go right to the jail?
I don't have to.
Okay, all right. Judge, those are my questions.
Redirect.
No, sir.
Witness released.
Yes, sir.
Thank you, released.
Yes, sir.
May I approach, Your Honor?
Granted. What is this? This state's Exhibit 2 is admitted.
At this time, the state doesn't plan to call any other witnesses at this time, Your Honor.
All right. Mr. Mitchell.
Just argument?
All right. State,
Yes, sir. Right.
make your arguments.
Okay. Well, I think, Judge, under 907-041, the offense, the conduct that happened is, would fall under that statute as a dangerous crime. If you look at 907-041, 5A4, it specifically defines use of explosive devices as a dangerous crime. The situation here, we have a defendant who drove from Escambia County, Pensacola, with firearms and explosives in his car, purposefully to come to Fort Walton Beach to the local Harley-Davidson shop to confront a rival motorcycle gang and confront them. During that time, what the evidence gathered, or the information gathered, is that he pointed a gun, made threats at them, and then driving off threw the explosive device out of the car, caused damage to a building. We're very fortunate that it didn't harm someone, badly in the situation. Not only is it's defined as a dangerous crime under that statute, but based on just the evidence that we presented today, there's a substantial probability that Mr. Simons committed the crime. The eyewitnesses identified him, his appearance, what he was driving. He was pulled over a very short time later, and it was the same description with the beard, bald head, had a motorcycle jacket, firearm, and explosive device, and that's what they found. And then, in his own words, he said, well, I should have thrown it in further in the parking lot into Harley Davidson. There's kind of an admission. And so, based on that, the state's position is it's a substantial probability that he committed the crime. As to the fourth prong, the state would argue that there is no way for the court, no other way to protect our community from Mr. Gregory other than incarceration, that he's a danger to the community. We have someone who, like I said, crossed county lines with dangerous explosive devices, with a firearm. He brandished it, pointed it at people, then threw the explosive device, and it went off, from what it appears, not where he intended it to go off. When you have a restaurant like Jimmy John's, that's a very, it's popular among our citizens, and it's highly frequented, and it's very dangerous. That showed a total disregard for the public safety. And you have a situation where he knows he has illegal things that he needs to get rid of out of his house. So he's now trying to get rid of evidence that he would be associated with this crime. And that's, I don't know any other way other than incarceration to protect our community. And so the state is requesting that the court hold him without bond.
Mr. Mitchell.
Paragraph 1-4 of his petition is what I was hoping that we would hear more about today. The heading of the paragraph states an assertion, and the first paragraph in it states the assertion again, and then follows it up again. So they're saying there is no other way to assure the safety of the community than incarceration, and as evidence that we'll say it again, and then we're going to say it again. These conclusions don't just make it so. Here we have, the court can take notice of the fact that this is a gentleman who's 41 years old, who's never been arrested at all, and the court has broad scope to do things to assure his appearances and assure the safety of the community. And I trust that the court doesn't need me to give it a list of these different things. In that area, the government has failed, and detention is not appropriate. I appreciate your attention, Judge.
Any rebuttal?
Briefly, I would just say the fact that he had materials that he stashed, he removed. Now, if he's let out, then now he can go and get them because he's moved them and hid them somewhere else. And whatever beef that he had with the people that were out there, that hasn't gone away. So, and when you have someone that's as reckless as throwing a bomb out the window near a restaurant in a parking lot with a lot of people, while there's a barbecue or a cookout, that to me, I don't know how else you could, what community sanction you could give the defendant that would protect the community from someone that was willing to do that and then have access to, we're not even sure what he was hiding. So. That's the state's position, Your Honor.
All right. The court has carefully considered the evidence that it's heard today and the provisions of 907.041, also the provisions in 903.046. The court has listened carefully to all of the testimony and observed the demeanor of the witnesses. The court is particularly struck by the demeanor of the witness from Jimmy John's, who, reliving the events here in the courtroom, had trouble even describing the event because of the fear you could see on his face from an explosion going off while he was working and being shattered with glass as a result of the explosion. You could see the fear on the face of the witness who testified regarding her observations at the motorcycle shop and the circumstances involved there, particularly when she said, "I told everybody to get down." The look on her face was reliving the terror of that moment. The fact that this is a crime of extreme violence and danger to the community is of no doubt, and it's so classified by the legislature and provides for this proceeding that we have here today. And it's clear, based upon the defendant's own words, that there's probability, great probability, I think beyond what the statute requires for the court to find, that the defendant committed this offense. So those two criteria are met by the evidence the court has considered. So now the court has to consider what, if any, conditions of release would keep the community safe. And I realize this statute is relatively new. We're still exploring the extent of it and what the conditions are. But the court is informed by how we look at what the purpose of bond and bail is, right? And if we look at 903-046, the purpose of bail determination is to ensure the appearance of the criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. Nothing in the amendments to 907.041 have changed those provisions. They've simply reinforced the circumstances under which the court can exercise its discretion to hold the defendant without bond or bail when the danger to the community is unreasonable. I think about other circumstances where the state may ask to revoke a defendant's bond for post-release behavior, or some of the cases which inform the court of their ability to hold a defendant outside of the circumstances presented in the pretrial detention statute. And some of those are whether or not that it appears that the defendant would engage in behavior to intimidate, coerce witnesses. The defendant's own coded words, I say, through his jail call suggest that he's instructing someone he's communicating with to take care of someone who is speaking out about the situation. He discusses with someone to be sure to get that stuff out of my house. He discusses hiding or secreting away firearms, which were a material object of use of his commission of this crime. Get rid of my desk. One can only infer from that testimony that there were other materials in there which would be subject of further inquiry by the authorities. Otherwise, why would it be important to get rid of the desk? That would be, as I think his correspondent during the phone call suggested, would be tampering with evidence. The court finds clearly that there are no conditions which the court could impose on this defendant which would keep the community safe based upon the defendant's own behavior, particularly post-arrest, where he clearly appears to engage in any behavior necessary to intimidate witnesses against him or to assure that he has access to things that he needs to commit future crimes of a similar nature or against any witnesses in this case. So the court finds it appropriate under 907-041 and considering all the factors in 903-046 that the defendant should be held without bond pending disposition of this case. I'll direct the state attorney to produce an order which recites the court's findings in this case, and to pass that by Mr. Mitchell following my regular protocol, which is I want one email from the state indicating you've passed the order by Mr. Mitchell. He can approve the form of the order, and if there are objections, you must provide those to them directly. I'll resolve the objections. If I can't, we'll have a short hearing to resolve objections as to the form of the order only. Any questions? And consistent with my regular approach, you'll have 5 days, no more, to just complete the form of the order, 5 days to do the objections, so I'll expect no more than 10 days to expire before I see an appropriate form of order and any objections on my, in my queue. Any questions?
No.
All right, all right, all right. With that extended hearing, we're going to take about 10 minutes to let our lawyers get everybody queued up for our next hearings. I know we have also a 2:30 suppression, right? But we also have our arraignment docket. So I'll let the state and the defense put their heads together and see how the best way to do that, to arrange to make that work best for us, considering our timing, okay? Okay.
Just so that you don't go back there and read a bunch of case law from your client, we did resolve the suppression issue, so there will not be a substantive motion to suppress hearing
The new case.
the new case.
You know, that's the most fun a judge has, is reading nifty case law.
We were, I think we were both ready to do it, but I think we both got kind of what we were after,
All right, so do you want to dispose of that before we take our recess?
No, I just want to let you know in case you were planning on going back there and reading the cases and you emailed.
Okay, all right, so
Who knew
we'll
is-
take 10.
All right, please.
10 minutes.
10 minutes, counting down.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Arraignment Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Wallace is approaching 25 CF 126. We'll acknowledge the 3-count information, waive its formal reading, and enter a plea of not guilty. Currently, this is scheduled on the May 12th pretrial, and I'd like to leave it there. All right.
Hey, we got have you have information sheet there?
Yes, I already have it, Judge.
Okay, very good. Thank you very much. Stay in touch with Mr. McKinney, and we'll see you back on that date.
What day? May 12th, but go ahead and make an appointment to come talk to me. Tuesday, Weaver. Ms. Weaver is present before the court in 25 CF 116. We would acknowledge the receipt of a 2-count information, waive its formal reading, enter a plea of not guilty. Given that Ms. Weaver is 19 years old and doesn't appear to have any criminal history, I'm going to engage with the state in hopes that we can reach some sort of a PTI agreement.
Okay.
If that is the case, then it may resolve prior to the May court date, but I'd like to keep the May 12th court date at this time.
All right, very good.
Is that it? Be sure you fill out this piece of paper here with your contact information before you leave. Yes. Okay.
Thank you.
Good day.
Aiden York. Mr. York is here in 25 CF 168, and we would acknowledge the receipt of a 5-count information, waive its formal reading, enter a plea of not guilty. It is currently scheduled for the May 12th pretrial, and I'd like to leave it on that court day.
All right, very well. Thank you. Be sure to complete that information sheet. Mr. Kleins? Or, oh, Mr. Deese. Sorry, Mr. Deese.
We have Ethan Zane Rasco, 23 CF 2643, 23 CF 2645. Your Honor, he is here for sentencing from a PTI revocation. We have, state and I have reached an agreement with Mr. Rasco, the state reached an agreement. We've reduced it on a rights waiver, although I don't think the court needs a rights waiver, but it is for informational purposes on the sentence. May I approach, Your Honor?
Granted.
Together with the score sheet.
All right, so he previously pled, and now we're just doing the sentencing by agreement on this agreement, right?
That's right, Your Honor.
All right, and this is the state's agreement?
Yes, sir, that's the state's agreement.
And those terms are, that's basically his original plea agreement. He has just re-signed.
All right, so on count one, it's the 5 years of probation with $40 a month cost supervision, attend and complete a 90-day minimum inpatient treatment program and enroll in treatment within 60 days, no alcohol or drugs without a prescription, random urinalysis, 2 AA meetings a week. When not in the inpatient treatment, restitution order be reserved as to any amount, all fees and costs mandated by the statute. On count two, it's withhold. So withhold on all of them, right?
That is correct, Your Honor.
Withhold, same terms and conditions, 5 years concurrent. Count three, it's a withhold 1129 concurrent probation. And then on 2645, 5 years concurrent, same conditions with 2643, correct?
That is correct.
All right, and it's a downward departure, but the state stipulates that it's appropriate under the circumstance.
Yes, we do.
Okay, that'll be the sentence and judgment of the court.
Judge, I know the state wanted to make certain on the record, when it says 2 meetings per week when not in inpatient treatment, Mr. Rasco is under the understanding, just so probation knows, for the entire 5 years of probation, he's going to be doing 2 AA meetings per week.
Correct.
When he's not in inpatient treatment.
When he's not in the inpatient treatment.
That's correct. Thank you, Judge.
Thank you.
Good seeing you. Have a good day.
Y'all as well. Thank you. Do you want to do Lanu now?
Sure.
Let's get.
Your Honor, this is Mr. Lanu.
Your Honor, this time, the state, in exchange for a forfeiture of the firearms in this case, the state is going to announce a dismissal of this case, Your Honor.
Okay, who has possession of the firearm?
The Okaloosa County Sheriff's Office right now. They're just going to remain in the custody of Okaloosa County Sheriff's Office. He's not allowed to get them out.
Okay, and I've read the addendum probable cause. There's no assertion that anyone else has lawful ownership. I believe the addendum probable cause indicates that Mr. Liu claimed ownership and purchase of the firearm in question.
Correct, Your Honor.
That's correct.
Okay, all right, so based upon that, so the firearm is forfeited, and with that, the state announces a null pros.
That's correct, Your Honor.
Okay.
Your Honor, I have one more on the arraignment docket in the gallery, if I could call him.
All right, very good.
Scott McKean.
May I approach Madam Clerk with some of his contact forms?
Yes, please, Mr. McKinney, thank you.
Mr. McKean is present and approaching, Your Honor. We will acknowledge receipt of a one-count information, waive the formal reading, enter a not guilty plea. Mr. McKean is already on the May 12th docket, and we will just leave it on that May 12th docket.
All right. All right, very good, thank you. Complete that information sheet if he hasn't done it. Okay, very good, thank y'all. Yes.
I'm sorry, what was that just set for, Your Honor? I'm sorry.
512. And then what about Rybicki with Mr. Cobb? Have you heard about that?
He is, I literally just ran into him downstairs.
Mr. Cobb or Mr. Rybicki?
Mr. Cobb. Mr. Cobb, let me text him and see if I can get him up here.
So for this one, there's two cases that we're tracking with a 25 CF 13. Mr. Cobb filed a not guilty plea in that case, but the other two cases that we're tracking are still on.
So he may think they're moved to the 512, the other case on the 512 docket?
Mr. Cobb, I told you in 1 8 by
Okay,
I told him to tell the city about your own thing.
okay, all right.
Currently, all cases are set on March 10th.
So he may think these are passed because they're all set on March 10th. All right,
Possible. I did text him, Your Honor.
Mr. Koch.
Yes, Judge. If we may call Mr. Jose Sanchez, and I do have the Spanish interpreter present.
Very good. And Madam Interpreter, raise your right hand. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing? Thank you.
Judge, this is Mr. Jose Sanchez. Receiving the information, will be entering not guilty. We'll waive formal reading. And I provided my client my card, and he understands to make an appointment with my office to come see me before our next court date, which I believe, Your Honor, is the 3/10 pretrial.
Thank you. How you get him to fill out the information sheet with the help of the interpreter?
Yes, Your Honor.
I show it's on the May 12th docket.
May 12th docket.
Thank you, Madam Clerk. May 12th. I'm just writing the next court date of May 12th on the card, but still make that appointment. Excellent. Thank you. Judge, if I may call Mr. Julian Saavedra, who's present and approaching in 25 CF 118 and then 25 CF 121. Is it Saavedra? Yes, Saavedra. Might have just been on the. Your Honor, there's no physical copy in the courtroom, but I do see that both case numbers have been filed upon. At this time, we'll be entering not guilty and waive formal reading in both cases and request it be kept on that 5/12 pretrial docket, Your Honor.
All right.
And I will have my client fill out that contact information before he
Very
leaves.
good. Thank you very much. So 512, you'll get the information formally later, but they're asking you to fill out the information sheet with the contact. That makes certain the clerk and everyone has the good information so you don't miss court date, okay?
Yes, sir. Excellent.
Thank you.
Thank you, Deputy. Mr. Cobb's here. You do? Yep.
All right, Mr. Cobb, Rybicki. And we were just debating that since both these cases and the new case are already set on the next docket, maybe there was confusion, so.
I kept checking the dockets to see, but I did file, in all of Peter Rybicki's cases, I know written pleas of not guilty have been filed. I think it's already been passed to the next pretrial date. And then there was another one you had set on today's date.
I think we were just on a status conference today on both those cases.
Right. The other one was Riccio, I think. And so I'd like to leave them both on the natural pretrial date after the arraignment.
I don't have any other for you today.
Salvatore Riccio is
Yeah.
on the docket.
I think he might have been on the morning, is he on the morning docket?
No, he's on the plea docket.
There was a not guilty plea filed on that one, so it's already moved.
Okay.
All right, so Rebicki's on 310.
Thank you, Judge.
Thank you, Mr. Cobb. Good day.
You too.
And Judge, the rest of mine are in custody.
All right. We got, I show 3 folks here today without counsel. So if you're here today, you don't have a lawyer and you want a lawyer, everybody's entitled to a lawyer. If you can't afford one on your own, the state constitution, the federal constitution require that we appoint a lawyer on your behalf, and that lawyer will be paid for by the state. To do that, you've got to complete an application. However, I'll call you down one at a time. The state may have an offer to resolve your case. If you feel comfortable accepting that offer without the help of a lawyer, you're free to do that. I can answer some questions about an offer, like how does it work? But if you start asking questions about what does that mean for me later, how do I resolve this, those are all questions that have to do with a lawyer. So first I have Chandra Moore. Good afternoon. You're here today without a lawyer? You want a lawyer? You will hear for the state have to say first.
I don't need a lawyer.
We spoke, Your Honor.
Okay.
At this time, the offer would be an adjudication of guilt, 2 years of probation, 24 hours of community service work, no trespassing at Eglin Federal Credit Union, no contact with the victim, who is Lisa Newbegin. I'm sorry, Lisa. And then that we would reserve on restitution for 90 days.
All right. So you feel comfortable accepting that without the help of a lawyer?
Yes, I do, sir.
Okay. Have you been previously adjudicated as a felon?
Yes, 13 years ago.
All right. So you understand the implications of that?
Yes.
And you understand that if you wanted to accept that today, that you're going to have to plead no contest to the charges?
Yes.
And by pleading no contest, what I would understand you to say is that you believe the state has the evidence necessary to prove your guilt, and you're not going to contest that.
I'm not going to contest it.
And that you're going to waive your right to a trial by jury.
Yes.
And you're agreeable to accept that in the 2 years of probation with the restitution to be established and no contact with the victim.
Yes, sir.
Okay. Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay. You put your hand down. So you agree to accept the state's offer?
Yes, I do.
And you believe you have all the information you need to do that without the assistance of an attorney?
Yes, I do.
And you believe a no contest plea is in your best interest at this time?
Yes.
And you understand you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And by making this plea at this early stage of the proceeding, you're waiving your right for a lawyer to challenge the case factually, legally, or technically?
Yes, sir.
And you'll accept the 2 years of probation?
Yes, sir.
With the adjudication of guilt?
Yes, sir.
Okay. The court will find, and what are the proper fines, fees, and costs, Madam Clerk?
$515.
$515 in this case are your fees and costs, and then you'll have the $40 cost of supervision while you're on probation. And the restitution amount was?
We're reserving on
Reserved.
Reserve.
And so
I would just want no trespass at Eglin Federal Credit
All
Union
right.
to be stated, and 24 hours of community service work.
no trespass at credit union and 24 hours of community service. Didn't you say there was an individual victim?
Oh, I just want no contact with the victim, Lisa Newbegin. I don't think that there ever was. I just want to make sure that
Okay, no contact with, can you spell the last name for Madam Clerk and also for probation?
Newbegin, Newbegin.
Okay.
And
All
then,
right.
Judge, if I may, real quick, approach the defendant, show her the score sheet that we have.
Very good.
So this is just, this is the current charges right here, and these are the priors that we have. And then this is your total points right here, so it shows you don't score correctly, 32 total points. And then your 2 years of probation checks.
All right. Now, if you'll just check in, you have to step over here and get your fingerprints, and then if you'll check in with probation before you leave, they'll give you some instructions. Andrea Page. Did I get your name right? Okay. All right, you're here today without an attorney. You want an attorney, or would you like to hear what the state has to say first?
I want to hear what the state got to say first.
Okay.
Your Honor, at this time, it would be we would offer a withhold of adjudication, 18 months of probation, $615 in court costs, a substance abuse evaluation within 30 days, and begin any recommended treatment within 60 days with random urinalysis, 24 hours community service work.
You feel comfortable accepting that, or do you want to talk to a lawyer about that?
I feel all right with that.
Say again?
I say it's okay, yeah. I
You
feel
can-
okay with it.
Okay. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay. Now, in this particular case, you understand that you're accepting the state's offer to a plea to possession of a controlled substance without a prescription. And by doing that, you're pleading no contest to that charge. And that says to me that you believe the state has the evidence to prove your guilt, and you're not going to contest that. You understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
And you understand by making this plea, you're waiving your right to challenge the charges against you legally, technically, or factually,
Yes, sir. I understand.
which a lawyer could do for you.
Yes, sir. I understand.
And it's very early at this stage of the proceeding.
Yes, sir.
Okay, you believe that this is the best thing to do for you under the circumstances.
Yeah.
You understand you'll be on 18 months of probation with the standard conditions of probation, plus the requirement of the 24 hours community service work and the random testing that was been recommended.
And the substance abuse
And
evaluation.
Substance abuse evaluation and recommended treatment.
Yes, sir. Is there any way I can get adjudicated withheld?
Yeah, it's a withhold.
Okay.
It is withhold.
All right.
He's offering a withhold.
Okay.
And then you'll have the $615 fees and costs,
Okay.
and then $40 a month cost of supervision while you're on probation.
Yes, sir.
Is that what you're willing to do?
Yes, sir.
Okay. The court will find the plea to be freely and voluntarily entered into. I'll accept the plea with a withhold. If you'll check in with probation before, oh, hold on just a second. Mr. Gomez is going to show you the score sheet to show you what your score is and that this is a guideline sentence.
This is the current charge. You only have one prior battery, so
Mm.
it's just 2 points, so for a total of 60.2 points. And then on this page right here, all I did was mark the probation box and then what you were sentenced to 18 months. No objection?
All right. And if you'll step over, probation will give you some instructions. They're sitting right there in the front row, and they'll give you instructions on what you need to do, okay? Thank you. All right, next I have, is it Jonas, is it Suri? Did I get close? Come on down. What is the proper pronunciation? Swire, thank you. I'm sorry for that. All right, you're here today without a lawyer. Would you like a lawyer to help, or you would like to hear what the state has to say first?
Can I do like both? I hear like both sides?
Sure, you can hear what the state has to say, and then you can decide whether you need a lawyer or not.
It'd be an adjudication, 3 years of probation, no contact with the victim, no trespass at the location that this occurred, substance abuse evaluation, anger management, 100 hours of community service work, no alcohol, no drugs, random urinalysis and drug testing. You've got to maintain employment.
Would you like to talk to a lawyer?
Yeah, we need some.
All right, here's an application. Fill that out, pass it back in. Don't leave until you turn it in and get a new court date.
Yes, sir.
Okay?
Thank you.
Thank you, sir. All right. I guess, Mr. Kleins, I show one for you and then several more for Mr. Koch.
I still have Mr. Neely, too.
Oh, and Mr. Neely from this morning, that's right.
Your Honor, this is Mr. McCotter. Go ahead. He is executing a plea agreement to resolve this case. We will acknowledge receipt of a 3-count information. Mr. McCotter is going to be entering a no contest plea on counts 1 and 3 as charged. In exchange for the plea, count 2 is going to be null pros by the state. The agreed upon terms are that Mr. McCotter is going to be placed on 2 years of probation. Special conditions are that he will pay $183 in restitution to Ashley Hayes. He will also have no trespassing at Ms. Hayes' work or home. He will also have no contact with Ms. Hayes. He will perform 24 hours of community service. I didn't write it on here, but obviously he's going to be assessed $615 in court costs, $150 in public defender fees. I would note, Your Honor, that Mr. McCotter is on supervision out of Walton County. I was advising him today, just now, if he's released from the Okaloosa County Jail today, he needs to report to probation in Fort Walton Beach before he goes and handles Walton County. So the probation sentence here is going to be concurrent to any other supervision. That actually supervision he's on in Walton County is technically out of Alabama. So if I may approach with a score sheet and plea agreement?
Granted.
And what is the discipline?
Oh, I'm sorry, adjudication.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Klein said and you signed the written plea form?
Yes, sir.
How old are you and how far did you go in school?
38. I didn't complete school, you know. 10th grade, wouldn't take my GED. I didn't complete it, but.
Okay. You able to read and understand the plea
Yes, sir.
form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Klein's just told me?
Yes, sir.
Do you understand that by this plea you're pleading no contest to the charges that were announced?
Yes, sir.
And that says to me you think the state could prove your guilt and you're not going to contest that?
You got to say yes, sir.
Yes, sir.
Okay. And do you understand by making this plea that you're waiving your right to a trial by jury where the state would have to prove you guilty?
Yes, sir.
All right. And in this case, you'll be adjudicated guilty of counts 1 and 3, and you'll be on 2 years probation, and that's going to be concurrent with any other supervision. And you got the $183 of restitution, plus the 24 hours community service, and no contact with Ashley Hayes, and no trespassing at her work or her home.
Yes, sir.
Okay. Mr. Klein's answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how Mr. Klein's has represented you?
Yes, sir.
The court finds the plea to be freely and voluntarily entered into and will accept the plea.
All right, man. That's a copy for you.
Let's step over this way to have your prints taken.
Yeah, if you don't get out before 5 o'clock.
Any way I can get called up?
And so, I'm sorry, who are you, please?
I'm Tanya Pratt.
Tanya.
Thomas, that's your case.
Tanya Marie Pratt.
Okay. Yes, ma'am. Mr. Koch.
Yes.
That's your client, right?
Yes, I'm seen on the docket, Your Honor.
Come on down.
I'm so sorry.
No, it's okay, ma'am.
Oh, shit.
You are correct. This is Miss Pratt. We have the... Let me look first. Yes. Tanya Pratt. Thank you so much.
I'm sorry.
No,
I gotta
you're
go to
fine.
work.
Judge, this is Miss Pratt in 25 CF 162. Receiving the information will be enter not guilty, waive formal reading, and I'll provide my card and get my client to get the contact information filled out, Your Honor.
All right.
And
Your Honor,
I
just-
How'd you know I was gonna plead not guilty?
Just for the sake of efficiency and just to let Mr. Koch know, the offer right now as it stands is an adjudication of guilt, 18 months probation, 24 hours of community service work, substance abuse evaluation within 30 days, treatment within 60, standard fines and court costs, Your Honor. just in case that might resolve something.
Thank you, Mr. Gomez.
I don't want to accept that. I want to not.
Yes, ma'am, Ms. Pratt. We'll keep it to not guilty, Your Honor, and please keep it set for that 512 pretrial docket.
Very good.
Thank you.
And fill out that information sheet. Well, you already did. Thank you, and we'll see you on 512. Stay in touch with Mr. Koch. It's
I will.
important he has contact with you to help you resolve your case.
Okay, thank you.
Did you get this? I know you have, yeah. Please call, make that appointment, all right? Yes,
I
ma'am.
will do. I need this or this.
You can take that with you.
Okay, thank you.
You're welcome.
Have a good day.
Judge, this is Mr. Michael Riley in 25 CF 127. Okay. Yeah, I did see that. Your Honor, there's not a physical hard copy, but I do see the information online. We'll be enter not guilty, waive formal reading, and request it be kept on that 512 pretrial docket.
All right, 512 it is. Thank you.
Okay, I'm gonna bring out everything I got. So this was kind of the last piece left. Okay. So I'll see you tomorrow.
All right, thank you.
Mr. Kleins?
Yes, sir, Your Honor. Your Honor, Mr. Neely is signing an agreement to resolve the violations in these cases. At this time, Your Honor, Mr. Neely is going to be admitting the violation. Specifically, he's going to admit count 1, count 2, count 5, count 8 in the violation report. Yes. The agreed upon disposition is a little bit unusual. Mr. Neely is going to be surrendering all of his prior credit. The agreement that he has with the state is that today he will be starting a 9-month county jail sentence. There's actually technically no credit to announce on that. So it'll be 9 months county jail. His previous supervision in these 4 cases would be revoked and terminated. He would be assessed a $100 cost of prosecution for each one of those cases, a $50 application fee, and a $100 public defender fee for each case he was previously adjudicated. May I approach?
Granted.
And Your Honor, this is a downward departure for the purposes of legitimate uncoerced plea bargain.
All right. Mr. Neely, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, sir.
All right. Now, you put your hand down. You heard what Mr. Klein said, and you signed the written plea form.
Yes, sir.
And you understand by this plea arrangement that you're admitting the violation.
Yes, sir.
And that says to me, Judge, I violated just the way probation says it did.
On the specific counts that we announced.
Right.
Yes, sir.
Yes, sir.
Okay. And you understand by doing that, you're waiving your right to a trial where the state would have to prove that.
Yes, sir.
Now, a material part of this agreement is that you're agreeing to a net sentence of 9 months.
Correct.
And is that from today?
Yes, Your Honor.
All right, so your 9 months starts today.
Unfortunately, yes, sir, I understand that.
Okay. From what I picked up from the talk is that's part of the negotiation because you would be facing
I think it's 21.88 months, Your Honor.
21.675 months in the Department of Corrections. So is that the reason you're willing to waive all your prior credit is to get 9 months in the county jail versus the 21 months?
Yes, sir.
Okay. All right. Mr. Klein's answered all your questions about this and how it affects you,
Yes, sir.
and you're satisfied with what's happened
Yes,
and
sir.
how Mr. Klein's has represented you.
Yes, sir.
Now, you've got several cases here, and my click check is you got some fees and costs that are outstanding that you're going to have to pay. So once you do your 9 months, how much time do you think you need to get that squared away, get those things paid off? Think 24 months will be enough?
Yes, sir.
All right? And if you need more time, just ask for it as long as you're making payments, okay?
Yes, sir.
Because the goal here is to get you to make those payments. And so if you need a little more time and you're making payments, it'll be okay with me.
Yes, sir.
Okay? All right, the court will find the plea to be freely and voluntarily entered into, and will accept the plea with the adjudication. I think he's been previously adjudicated, though.
Judge, this is Mr. Dylan Riggins in 25 CF 169. And the information has been filed, Your Honor. We'll acknowledge receipt of the information. My client does want to enter a no contest plea. May I have just a brief moment, Your Honor?
Yes, sir.
Your Honor, this will be a no contest plea as charged. It will be an adjudication of guilt, 36 months of standard probation, $40 per month cost supervision. There's $615 in court costs, $150 in defense costs, 24 hours community service, substance abuse evaluation, and any recommended treatment. No alcohol, no drugs without a valid prescription, random breath tests, random urinalysis, maintain gainful employment, or submit 3 job applications per week. All counts to run concurrent. And Your Honor, I did review this with my client, and I explained that this is early in the process. We're at arraignments today. And of course, if we enter this plea, I haven't seen any FDLE and haven't thoroughly ran through this case yet, but my client understands that and he wants to move forward. If I may approach with the signed plea form.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes.
How old are you, and how far did you go in school?
I'm 26, and I made it to 11th grade.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And it's what you read in the plea form, what Mr. Koch just announced for
Yes.
me. Do you understand that you're pleading no contest to the charges?
Yes.
And that says to me that you think the state's got the evidence to prove your guilt and you're not going to contest it.
Yes.
Do you understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt?
Yes.
Okay. And as Mr. Koch said, it's early in the case, and he hasn't had a chance to look at everything and maybe challenge the case legally, factually, or technically. But you've told him that you want to go ahead and make this plea because you think this is the best disposition for you at this time. Is that right? Okay. And with that, it's 36 months standard probation with the cost of supervision, the court cost, community service, substance abuse evaluation and treatment, no alcohol or no drugs without a prescription, and the testing, as well as trying to get a job or get a job and maintain the job or submit applications. I also add, if you think you want some training and you find something that you believe will fit your needs, then I would consider that as well. So if you say vocational training or some classes that you think will help you get ahead, then I find that that will qualify. Because my goal is to try to set you up for success. So if you find something and you tell probation you want to do that, then I would consider that as an alternative to you working or looking for a job, as long as you're making progress and you're getting training to set yourself up for a job. Does that make sense?
Yes, sir.
So if you want that, let probation know, and I'll support you in that, all right?
Yes, sir.
All right. With that, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Angel
You're welcome.
Rosa Reyes.
Your Honor, I believe that's all I have for today. May I be excused?
I'm sorry?
I believe that's all I have for today.
Yes, sir. Thank you. Good day.
This is Mr. Angel Rosa Reyes in 25 CF 108. May I have a brief moment?
Yes.
Please, thank you. Judge will acknowledge receipt of the information, will enter a not guilty, waive formal reading of the charges, and request it be kept on that 512 pretrial docket, Your Honor.
All right.
Thank you, Judge.
Mark Snyder.
Thank you. Yes, sir. And Judge, this is Mr. Mark Snyder, 25 CF 130. I'm coming. You take your time.
How you doing?
Judge, we're going to be entering a not guilty, waive formal reading. Request to be kept on that 512 docket, and I know the court's aware, but we recently signed that order for an evaluation with Dr. Zeman, Your Honor.
All right. All right. We'll leave it on for then. Thank you very much.
Excellent.
What are we doing?
Take this with you.
John, you clap.
But he'll be coming soon to see you.
Okay, now, what?
No, I don't want to discuss it. All right, Mr. Snyder. Yes, sir. You're welcome.
Oh, he left. I said that he should stay and talk to his attorney, but I guess he bolted.
Are we talking about Jonas?
The young gentleman with the older gentleman? Okay, he might be out. He asked me if he could go. I said, no, I wouldn't. I'd talk to your attorney first. And he, he did fill out the form, though.
Well, it looks like he qualifies. Did you talk to him, Mr. Koch?
Briefly enough to give him this to fill out.
What does the state want to do?
Well,
If I can step out and give him a call.
yeah, I don't want, he was here, and I guess he thought maybe the court was saying that he had an attorney. He's not out there.
I really think that he probably thought he could leave, even though I said I wouldn't. I would stay and talk to my attorney.
Okay.
I agree.
Well, we'll see if Mr. Koch can get him and
You can ask.
Yeah, could Ms. Barrickman and I approach on an unrelated case?
Did you see a young man about 6'3" with dreads and an older man leave?
yes, you may.